Registrar. Yes. Can we register? Call 01, please. 01. 01. Registrar. 01. Registrar. Can we call 01? Registrar. Good morning, Registrar. Registrar, good morning.
Good morning, my lord.
Can you call 01?
Yes, my lord. The first judgment on the list, CA/B/EPT/gov/1/2021. Action Democratic Party ADP. Iboy Lucky Emmanuel and Independent National Electoral Commission INEC. People's Democratic Party. Obaseki. My lords, parties are absent, my lord.
Parties are absent.
Yes, my lord.
Appearances for 01, please. Appearances. 01. Council. Appearances for 01.
My lord.
Yes.
K.E. Mosier.
Ken Mosier.
My lord. Yes, my lord. I appear for the third respondent.
For the third respondent?
The others are not announced.
The appellants are not announcing. Ken Mosier for the third respondent, yes. We are with you.
My lord, with me is Charity. Perhaps I should spell it for your lordship.
Charity, yes.
I will borrow here.
Okay, spell it. Could you spell E-I?
A for
A-I. We are with you, A-I. A-I.
G-U-O.
D-U-O.
G for Gregory, my lord.
A-I. G-U-O.
G for G-U-O.
Yes.
B-A. R-U-E. G-H-I-E-N.
G-H-I-E-N.
A for Apple, N for Nigeria.
Okay, I-A-N.
Yes,
Agobragian. Esquire. Okay, yes, thank you. That is for the third respondent. Who else is around? Yes.
Good evening, my lords. My name is Adetunji Oyeyipo.
Adetunji Oyeyipo, S-A-N.
Yes, my lord.
Adetunji Oyeyipo, S-A-N. You are for?
The second respondent, my lord.
For the second respondent, yes.
Rotimi Ogunesho, S-A-N.
Rotimi Ogunesho, S-A-N, with you.
Yes.
Ogunesho, S-A-N. Thank you. Who else? Okay. Registrar. Service.
My lord.
Service.
My lord.
Service.
The third respondent.
May it please my noble lords.
Yes.
May it please my noble lords.
We are with you.
My name is Kelvin Ugiagbe.
Kelvin Ugiagbe. Kelvin Ugiagbe. Just a minute. Kelvin. Not here. Ugiagbe. Yes. You are Kelvin. You are for whom?
I'm on. I think I've switched it on.
Kelvin,
please, your lordship.
Kelvin, can you spell your son name?
Kelvin, spell your surname.
UGIAGBE, my lord.
UGLA.
UGIAGBE, my lord.
Ugiagbe.
Yes, my
All
lord.
right.
My lord, I appear with my learned friend.
No. Please. You are for whom, Kelvin?
For the first respondent, my
Don't
lord.
appear with anybody. You are not SAN. For the first respondent. Yes, progress, please. Yes, who else on the screen?
Yes, may please, your lordship.
Thank you.
A.U. Asemota is my name.
A.U. Asemota.
Yes, your lordship.
Yes.
I respectfully appear for the appellants.
For the appellants.
And for the appellants, your lordship. We apologize for...
You appear for the two appellants or one of them?
Yes, okay, for the two appellants, your lordship.
That's okay. Thank you very much. The judgment in 01 was prepared by my humble self, and I will read it. This is an appeal from the judgment of the Governorship Election Petition Tribunal of Edo State, which sat in Benin City in respect of the governorship election held in that state on 19/9/2020. We said judgment was delivered on 29/3/2021 in petition number EPT/ED/Governor 01/2020. Are you hearing me? Are we together?
Yes, ma'am.
Yes,
By the final declaration in the said election, the first respondent declared the third respondent, who was the candidate of the second respondent, as the winner of the said election, and consequently issued the third respondent with a certificate of return, which was tendered and admitted before the lower tribunal as Exhibit A2. Being aggrieved by the said final declaration of the third respondent as the winner of the election, the appellant's petitioners, who are candidates and political party that participated in the aforesaid election, filed a petition on 5th October 2020 on a sole ground based on Section 138, 1A of the Electoral Act 2010 as amended, that the third respondent was at the time of the election not qualified to contest the election. Indeed, the sole ground of the petition, which is clearly stated in paragraph 9 of the petition, reads as follows, I quote, the third respondent, Godwin Onagese Obaseki, who was declared the winner of the election and returned elected, was at that time of the election not qualified to contest the election. The appellants, end of quotes, the appellants petitioners went further to plead the facts upon which they rely to support the ground of the petition, and at the end of the said petition, went on to claim the following reliefs from the tribunal. The reliefs are quoted A, B, C, D, E, F, G. Alternatively, they have reliefs A, B as alternative reliefs. Are we still together?
Yes, my lord.
Yes, my lord.
Pleadings were filed and exchanged. At the end of that, the trial, the lower tribunal held that the appellant's petitioners did not prove that the third respondent presented a forged and or false certificate to INEC first respondent, and that in all the circumstances that the third respondent was not disqualified to contest the governorship election held on 19/9/2020 in Edo State. Dissatisfied with the decision of the tribunal, the appellants filed a notice of appeal containing 14 grounds of appeal. The appellants and the respondents exchanged briefs of argument. In addition, the third respondent filed a cross appeal, which was the 01A. The relevant briefs of arguments are as follows. For the main appeal, appellant's brief of argument dated 28 April, settled by Nikide Eijuola. First respondent's brief settled by Yutayo Pato. Second respondent's brief settled by Gabriel Oladejo. Third respondent's brief settled by Kenneth Mosier, SAN, and appellant's composite reply brief to first, second, and third settled by Nikide Eijuola. Motions on notice. At the hearing of this appeal, there were two motions. The first is the third respondent's motion on notice of 11th May 2021, which prayed this court to raise and argue the issue of jurisdiction as a preliminary point, and for an order striking out the appeal for lack of jurisdiction. The second is the motion by the second respondent praying to set aside the service of the notice of appeal dated and filed on the 16th of April 2021, and on the second respondent through Gabriel Oladejo Esquire for being irregular and unlawful. In the motion of 11 May 2021 by the third respondent and the appellant adopted their written addresses. In the motion also of 11 May 2021 by the second respondent to set aside service of notice of appeal against the second respondent and the appellant relied on their affidavits and counter-affidavits in support of their positions. The thrust of the third respondent's argument on the appeal is that the appellant has failed to bring the party on record at the lower tribunal before this court, and having not obtained the leave of court to be strengthened and present, the notice of appeal is rendered incompetent, and the court is robbed of jurisdiction to hear the appeal. Learned counsel for the appellant is order and contended that there is nothing in Order 7 Rule 21 of Court of Appeal Rule 2016, which makes it mandatory to join to appeals persons whose name are struck out and where the appeal is limited to the challenge of the final decision of the court after the party had been struck out. For this petition, appellant's counsel relied on the decision of this court in the case of Adekegba, Minister of Defense. Appellant's counsel in the case of Mokodion and Nefared, Gadajo and Ajimobi, and APE and PDP, amongst others, referred to in the written address of the third respondent has not been applicable to the facts and circumstances of the instance case. I do agree with the learned counsel for the appellants that the failure of the appellant's respondents to name parties that the tribunal had hitherto struck out in their notice of appeal is not fatal to the competence of notice of appeal. The complaint of the third respondent is at best an irregularity which does not affect the competence of the appeal and does not go to the division of this honorable court in the circumstances of the case. Indeed, and as pointed out by the learned counsel for the appellant, the case of Omokodi and FRN, that is APE and PDP, relied on by the counsel for the third respondent are distinguishable and not enough to the facts of appeal. The third respondent's application is motion on notice of 11 May 2021 is refused, and the said motion is dismissed. On the second respondent's motion on notice of 11 May 2021, the appellant
you don't need to record this one. All these things
that the second respondent took further steps after the dispersed service of notice of appeal to pass second respondent proof of argument on 3rd May 2021. Incidentally, the said second respondent's brief of argument was prepared and settled by Gabriel Oladejo, who now purportedly denied service of the second respondent appeal on it. It is not of the nature of equity to appropriate and reprobate. Moreover, it is not equitable in the circumstances to grant the second respondent's application denying service of the notice of appeal to her. The second respondent application of 11 2021 is refused, and the second respondent motion on notice is accordingly dismissed. The main appeal. Are we still together, gentlemen?
Yes, Your Lordship.
Are you hearing me?
Yes, Your Lordship.
Yes.
The main appeal. In this appeal,
Yes, my Lord.
submissions of the appellant shall be considered on one side of the scale of justice, while the submissions of the three sets of respondents shall be considered in one piece as the submissions of the respondents. This is for the reason of the shared common interest among the respondents and also for convenience of writing. Learned counsel for appellants nominated 8 issues for determination of the appeal. The 8 issues are there, numbered 1 to 8. He knows them. On issue number 1, learned counsel for the appellant submitted that the lower tribunal held in law when they held at page 183 of their judgment as follows. It is the law that where there are relevant facts in the pleadings, the fact that the document is not specifically pleaded does not make it admissible. Inadmissible. We have fully examined the relevant paragraphs of the position of RW1 and the document tendered through him. We agree with the submission of the learned counsel for the second and third respondents that the deposition and the exhibits are fully accommodated within the pleadings filed by the parties. The evidence and exhibits are relevant to the facts in issue and will so hold. End of course for the tribunal. Learned counsel for the appellant submitted that the above conclusion runs contrary to the rules of pleadings and also to the provision of paragraph 12.3 of the first schedule to the Electoral Act 2010 as amended. Appellant's counsel submitted that the respondent must not only plead the documents he intends to rely on, is also bound to front load and attach also documents to his reply to the petition. Any such document which is not pleaded or front loaded along with the reply and where such is inadvertently admitted, it should be expunged and or excluded from the consideration of the court. Counsel for the appellants refer to the provisions of section 145(1) and 2 of the Electoral Act and cited numerous cases. They are there. And nudge us to expunge the documents not specifically pleaded by the third respondent and the testimony of RW1 in paragraphs 15 to 26 of his written deposition. The respondents, more especially through the first respondent, attended to appellant's issue 1 and submitted that there is nowhere in the statute where it is provided that evidence not front-loaded with respondent's reply would be automatically inadmissible. That it is the tribe's position of pleading and evidence that where there are enough relevant facts in the pleadings of the parties, the fact that a document is not specifically pleaded will not militate against its admission in evidence. They argue that the fact that the third respondent's university degree certificate is authentically issued by the University of Ibadan was pleaded in the reply of the third respondent. In fact, which makes the evidence of RW1 relevant as held by the tribunal. I do agree with the respondents. First, that admissibility is largely dependent on relevance. Second, that it is strike law that where evidence relating to documents are pleaded, so documents may not be specifically pleaded to be admissible. See the case of Abubakar and another Nightmare and others is cited. Finally, the court has held that admissibility of non-front-loaded evidence must be considered in the light of substantial justice to the parties. In the instant case, the appellants have not claimed or shown that the facts evidenced by RW1 and his documents were not evidence of facts pleaded. Neither have the appellants claimed that the said evidence was not relevant to the proceedings. In the circumstance, the tribunal was not in error to have admitted the deposition of RW1 and the evidence tendered to him. Issue number 1 is accordingly resolved against the appellants. In issue number 2, Daniel counsel for the appellants submitted that the report of PW2, which was admitted as Exhibit A11, was inadmissible in evidence. Daniel counsel for the appellants submitted that having at first mentioned at page 103 of the judgment that Exhibit A11 is relevant and admissible, the tribunal is not permitted to later hold that the said report is inadmissible. This, according to appellants, is synonymous with the tribunal sitting on appeal on his own decision. Also, that the tribunal could neither put the inadmissibility of Exhibit A11 on the demeanor of the witness, PW2, or even as offensive to the provision of Section 83 sub 3 of the Evidence Act, which they appellants said is not the admissibility of opinion evidence. For the principle that the opinion expert evidence cannot be caused by the term made by an interested person in the pendency of a suit under 83.3 of the Evidence Act, the appellant referred to a number of cases, including Ashford and heritage banking and others. Counsel for the appellant submitted that the certificate tendered by RW1 is the same certificate which the PW2 examined, along with the certificates of others who graduated from the same University of Ibadan in 1979, and arrived at the conclusion that the purported certificate Exhibit R2 was false. Are you still hearing me?
Yes, Your Lordship.
Thank you. He submitted that RW1 did not dispute any of the other certificates which PW2 examined along with Exhibit R2 and came to the conclusion that Exhibit R2 has features which were different from the other undisputed certificates. He submitted that RW1, not being an expert in document forensic examination, his evidence cannot displace the evidence of PW2. He submitted further that the tribunal cannot take solace in Exhibit R9, the judgment of the Federal High Court Abuja Division in suit number FAC/ABJ/CS74/2020, which had nothing to do with the appellant's hearing. He urged us to resolve issue number 2 in favor of the appellants. The respondents attended to appellant's issue number 2 in at least 3 senses. Indeed, offense against the provision of Section 83.3 of the Evidence Act. Second, that beyond demeanor, the tribunal evaluated the evidence of PW2 as against that of RW1 and indicated his preference on the issue, joined by is to prefer the evidence of RW1. Third, the tribunal was is equally right to have rejected the evidence of PW as a handwriting expert hired to analyze photocopies of the third respondent certificate to the effect that Ide and Co. counsel to the appellants requested the service of masters patterns forensic service a forensic document examiner to examine and compare the University of Ibadan certificate of Mikhailo Osemoka Asekome, University of Ibadan certificate of Emmanuel, and University of Ibadan certificate of Godwin Ogegase or Basek. That PW2 admitted under cross-examination that he never saw or reviewed the originals of the signatures on the certificates forwarded to him for comparison, and that he never visited the University of to verify the nature of the certificates. The respondents submitted that it became clear from the above that the evidence of PW2, including the report made by him Exhibit 11, was based on the information forwarded to him by the appellant's petitioners and those within his personal knowledge. That PW2 admitted under cross-examination that his company is a non-governmental, profit-making, and commercial organization, and all services must be paid for. He made no inquiry from the issuing authorities of the certificates. He was hired and paid by the appellant's petitioners, and the expiry report was made in the anticipation and for the purpose of the petition. Respondent referred to the case of Anagbodo and Farouk, and not just to hold that the evidence of PW2 and Exhibit 11 offend the provision of Section 83.3 of the Evidence Act, as was made by a party interested in the pendency of proceedings. On another wicket, the respondents referred us to the findings of the tribunal at pages 3346, volume 5, and 3347 as follows. First, at 3346, that I quote, "We have carefully reviewed the testimony of the PW2 and his report, and the circumstances leading to his making. It is the petitioner's appellant that provided the very foundational instrument of the test, that is the document marked Appendix A1, document marked Exhibit A2, and document marked Appendix D1. The very questions to be answered in the inquiry were provided by the petitioner's appellant, as stated in paragraph 12 of the report." Second, at 3347, still on the tribunal, I quote again, "In the event that we are wrong, it is a further holding that the testimony of PW2 and his report cannot stand in view of the direct and unambiguous evidence of RW1 and the exhibits tendered by the third respondent." The respondent submitted further that the appellant's PW2 devoted a substantial portion of the report to issues that were extraneous to the pleadings and which went to no issue. Such issues, they said, as purported differences in logo or differences in signature of the vice chancellor, registrar, distance, etc., were not raised. The said pieces of evidence therefore lacked any probative or evidential value. On this score, the respondent made reference to page 146 of the judgment, where a view that resolution of the genuine this case out of the University of Ibadan by the petitioners for respondents is fatal. According to an expert, determine the genuine is available and can be easily reached to determine the authenticity of certificate, and we so hold. End of quotes for the tribunal. First, I must say the determination of appellants is number 2, that I agree with the tribunal that the counsel to the respondents and the counsel to the respondent that the evidence of PW2 and his report, Exhibit 11, offend the provisions of Section 33 of the Evidence Act. This is because, unlike the avalanche of cases referred to in the appellant's brief of argument, including the case of Ashford and Heritage, Asegba and registered trustees, Peterside and Wabara, which likely deal with the admissibility of the evidence of surveyors and the consequent evolution through those cases of the rule that the evidence or opinion of such category of independent expert witnesses could not be caught by the provision of Section 33 of the Evidence Act, which frowns on the admissibility of evidence and or documents made by interested parties, witnesses, independence of a suit. The instant case is indeed distinguishable from those line of cases. It may be well that the professional restraints and code of conduct of surveyors and all such other experts make the law to look towards them as truly independent in the conduct of their professional affairs. In the instant case, the evidence offered by PW2 revealed that he was goaded, supported, and empowered by the appellants, circumstances which make me to join the tribunal in holding the view that the PW2 is indeed an interested party, and that Exhibit A11 was made in dependency of the proceedings and indeed for the purpose of the proceeding. The justification for the tribunal holding that the evidence and the report made by the PW2 are not admissible does not end there. The tribunal actually expressed its preference for the evidence of RW1 over and above that of PW2 in the determination of the authenticity of the third respondent degree certificate issued by the University of Benin in 1979. I start to wonder if it is not indeed right to have joined the tribunal in declaring the evidence of PW2 and its Exhibit 11 inadmissible. Consequence of my view that the evidence of PW2 and Exhibit 11 belong to the general rule of irrelevancy and inadmissibility of opinion evidence under the provision of Section 67 of the Evidence Act, as the evidence of PW2 could indeed not have been accommodated under any of the exceptions provided in sections 68 to 76 of the Evidence Act 2011. The parties joined issue on the forgery or otherwise of Exhibit R2. Now, the Black's Law Dictionary 8th edition, page 677, defines forgery as 1, the act of fraudulently making a false document or altering a real one to be used as genuine. 2, a false or altered document made to look genuine by someone with the intent to deceive. 3, the act of fraudulently altering, authenticating, issuing, or transferring a writing without appropriate authorization. In other words, all forgeries are species fraud. In the instant case, the uncontradicted evidence of RW1 has shown that there is no false claim by the third respondent in relation to Exhibit R2. Also, the existence and authenticity of Exhibit R2 through the evidence of RW1 negates any suggestion of a false claim to or on Exhibit R2 by the third respondent. The fact that there was no allegation and or proof of alteration of any false document as a genuine document for the purposes of comparing signatures or marks totally rule out the relevancy of the evidence of PW2 as exception to the general rule of irrelevancy and inadmissibility of opinion expert evidence under the provision of Section 67 of the Evidence Act. Indeed, if there was any allegation of forgery via alteration, what the petitioner's appellants needed to produce for comparison are 2 documents, one false and the other genuine, from the same genuine color source, one purportedly altered for false claims by the persons who alleged. The comparison of certificates issued to different candidates of and by the University of Benin cannot amount to any proof of forgery. Either way, and in all the circumstances, I agree with the respondents that the appellants failed to establish or to prove not only that Exhibit R2 was forged, but also that the first respondent is disqualified from participating in the said election. See the case of Okoko and Dakolo. Issue number 2 is therefore resolved against the appellants. On issue number 3, Learned Counsel for the appellants refer to paragraph 15 of the third respondent's reply to the petition and paragraph 32 of the deposition of RW2. He submitted that the petitioners filed a report to the respondent's reply to the petition, and in paragraph 7 of the said reply, the petitioner's appellants basically joined issue with the third respondent on his paragraph 15 of his reply as follows. 7, I quote, the petitioners deny paragraph 15 of the third respondent's reply to the petition. The petitioner said that A, the University of Ibadan does not issue certificates in A5 paper size. B, still unquote, A5 paper size is actually smaller than A4 paper, which is the size of the certificate photocopy submitted by the third respondent to the fourth respondent. The petitioner said categorically that Exhibit A5 being smaller in size, there's no way a photocopy from A5 into A4 will cause contents of the document to disappear. End of quote for the pleadings. Again, in paragraph 10 of the same reply to the third respondent's reply to the petition, the petitioner's appellants pleaded as follows, I quote, 10, the petitioners deny paragraph 18 of the third respondent's reply to the petition. The petitioner states categorically that the third respondent is merely telling lies about certificates, which he does not have. The petitioner said categorically that the University of Ibadan does not issue degree certificates in A5 paper size format. The petitioner will rely on A, other certificates issued by the University of Ibadan to show both the size of the paper and the signatories. B, evidence of forensic expert examiner to demonstrate that the third respondent is parading false and forged certificates. C, Form 01 and Form ECN to demonstrate that the certificates attached to both forms are different. D, personal data form submitted by the third respondent to APC to show in particular the purported University of Ibadan certificate attached to the said form bearing the passport of the third respondent. He submitted that the tribunal was totally wrong when it held that the issue of the certificate has become academic because of the tendering of Exhibit R2. He argued that contrary to the position of the tribunal, that the said Exhibit R2 is totally worthless because it's contrary to what the third respondent pleaded as the size of the certificate with the University of Ibadan issued it. That Exhibit R2 was confirmed by the evidence of RW1 to be bigger than A5 paper size, which is what was pleaded at paragraph 15 of the third respondent's reply to the petition. He submitted in the absence of Exhibit R2, which is inadmissible because it's available with the pleadings. There's no proof of the fact that third respondent indeed has any certificate issued by the University of Ibadan. Just a minute. Can I be excused to take water?
Escort places.
Escort, please.
He urged just to resolve the issue in favor of the appellants. On issue number 3, the respondents also refer to paragraph 15 of the third respondent's reply to the petition, paragraph 32 of the witness depositions of RW2, that the point being made by the third respondent and his witness was simply that the size of the original certificate as issued by the University of Ibadan is bigger, larger than the paper on which the photocopy submitted to INEC in 2020 was printed. That as a result of the difference in size, certain elements of the documents, university certificate to which date and signature of the registrar of the university were cut out by the photocopy machine. The respondent submitted that the appellants avoided this crucial point and went on to paragraph 7 and 10 of petitioner's reply to the third respondent's reply to focus on the fact that A5 is actually smaller than A4. That with regards to the real issue, which was whether the original degree certificate of the third respondent contained dates and signature of the registrar of the university, became resolved by the tendering and citing of the original containing the date and signature of the registrar of the university through Exhibit R2 by RW1. In deciding issue number 3, I agree with the respondent that having taken cognizance of the real point being made by the third respondent on why the date and signature of the registrar of the university do not appear on the certificate submitted to ANEC, and having seen the original containing the date and signature of the registrar of the university, the tribunal was indeed right when it held at page 143 of the judgment, 3347 of the record, I quote, that in our considered view, with the admission of Exhibit R2 in evidence, this argument turns out academic. What is material is that there is an original certificate before us. We do not think this a further consideration of paper sizes will serve any useful purpose. The above position of the tribunal cannot be faulted. Indeed, it is right. Courts of law are only obliged to consider and decide on the real issues in controversy. It's not the duty of the court to consider issues or points that have been otherwise resolved or have been overtaken by events. Issue number 3 is resolved against the appellants. On issue number 4, learned counsel for the appellant submitted that the tribunal was wrong when it held that the third respondent was not bound to attach any certificates to Form EC9 submitted to INEC, the first respondent. He referred to the provision of Section 162(1)J of the Constitution of the Federal Republic of Nigeria as amended, which provides He submitted that whether it is imperative for a candidate to attach a certificate to Form EC9 or not. Once the candidate decides to attach any certificate to the form, he has a duty to ensure that the certificate attached to that form is not a forged document. He referred to cases. He submitted that the person who has violated the Constitution cannot turn around to argue that they had no duty to have attached the certificate in the first place. That once the certificate is attached to a form submitted to annex, that candidate has automatically incurred the penalty in section 182 1B of the Constitution, and does not matter whether he added that Form EC9 actually directs and commands candidates to attach certificate. That item C date attach evidence of all educational qualifications. He ordered to resolve the issue in favor of the appellants. The respondents reminded us that issue number 4, which derived from ground 6 of the appellant notice of appeal, is appealing against the statement of the tribunal at page 143 to 144 of the judgment, 3347 to 3348 of the record, where the tribunal said the law whether case was necessary, the third respondent of his degree and other certificates is Form EC9, submitted to the first respondent during the 2020 Edo gubernatorial. The law is firmly settled that a candidate is not required by the Constitution or the Electoral Act to attach his certificate to Form ZFO001 EC9 before the candidate can be considered or adjudged to have requisite educational qualification to contest election. End of course. The respondent submitted that the above reproduced excerpt of the judgment of tribunal is merely an obiter dictum of the tribunal. That the issue of whether by law to submit his university degree certificate was never an issue raised by any of the parties. That was not the issue for the examination. The president of the General Tribunal will show that the above reproduced obiter was not and did not consider any part of the reasoning or ratio decided behind the decision of the court. That was just impossible. The respondents referred to the case of Onofok and Wema Bank and argued that the pronounced of a complaint never can able to. It is true that the parties to this case did not join issues on the question whether or not it was mandatory or discretionary for it to about the case and elections. Now, fought on the basis of the court and is not taking this. Not every pronouncement made by court or tribunal will be made in appeal, and appeal is usually against the amendment of the respectable made by the court in the course of the said judgment. Appellant's issue 4, based on ground 6 of notice of appeal, is indeed an appeal against obiter dictum. The ground of appeal is invalid and baseless, and issue 4 is accordingly discarded. Learned counsel for the appellants argued the issues 5 and 6 together as follows. He submitted that the tribunal was wrong when it held that the third respondent did not submit a forged certificate to the first respondent in the run-up to the gubernatorial election took place in September 2020. He submitted that the following facts could be said to have been established from the findings of the tribunal. A, that the certificate attached to Form EC9, Exhibit A4, which is also Exhibit A17, is different in content from the alleged University of Benin certificate issued to the third respondent, which is Exhibit R2. B, that apart from the incomplete or forged certificate attached to Exhibits A4 and A17, the third respondent also attached the same document in that state to Exhibit A5, which he had earlier submitted to the APC for their nomination. C, that the third respondent deposed to an affidavit in Exhibit A6, wherein he stated in clear terms that he graduated in 1976, which is different from or contrary to the date in Exhibit R2, the alleged University of Benin, which bears 1979. He submitted that RW1 was the witness of the third respondent who confirmed that the certificates in Exhibit A4, A17, and A6 do not have the signature of the registrar of the university and the date of issue, contrary to the standard operating procedure obtainable in that university. It submitted that when exhibits A4, A17, and A5 are juxtaposed with exhibit R2, it becomes obvious that the contents of exhibit R2 are not all reflected in exhibit A4, A17, and A5, which is the certificate actually submitted by the third respondent to INEC along with Form EC9. Submitted that is not in dispute by the University of Benin certificate, submitted by the third respondent to INEC at the date of issue, and the signature of the rest of the university missing from the document. In fact, first to the case of Maija and Gadama and Usman and Jibrin, and also to section 12 of the Evidence Act to say that having submitted the same defective certificate to APC in exhibit A5, the third respondent's action is deliberate and cannot be treated as an accident. He added that in exhibit A6, the third respondent proposed to an affidavit by which he deposed to graduating in 1976. Appellant's counsel submitted further that having sworn an oath twice that he graduated in 1976, the 1979 certificate R2, which bears 1979, cannot be said to belong to the respondent. He submitted that the third respondent was filled with this legitimate faith that rather it was RW2 Charity Bodale Iboriaga who testified on his behalf. He submitted that the opponent of the oath in exhibit A6 and A3 is the third respondent and not RW2, that RW2 cannot legally and lawfully claim that the third respondent made a mistake when the third respondent himself did not so state. He submitted that the evidence of the RW2 in respect of seeking to contradict or denounce exhibits A3 and A6 is hearsay and inadmissible. Appellant's counsel concluded on issues 5 and 6 that the purported certificate which bears 1979 as date of issue is contrary to the affidavit deposed to by the third respondent, where he claimed to have graduated in 1976, exhibit A6. He ordered to resolve the issues in favor of the appellant. The respondent's answers to appellant's issues 5 and 6 could be summarized thus. 1. That PW1 and PW2 that witness for the appellants to prove allegation of forgery and falsification are not credible witnesses, and that no court of law will attach any weight to their evidence. 2. That PW1 under cross-examination said that he never worked with the Independent National Electoral Commission, INEC, and the University of Ibadan to know whether the evidence of certificate of forgery is true or false. 3. PW1 also admitted under cross-examination that the averments in his written witness statement are not facts within his personal knowledge alone, but from the petitioner's appellants themselves. 4. PW2, the expert witness, admitted under cross-examination that the documents forwarded to him with certificate of the third respondent was never verified from the issuing authority to ascertain the true originality of certificate. 5. PW1 and PW2 never cited the original certificate of the third respondent, but merely relied on photocopies at their disposal in support of the allegations. 6. That the appellant's witnesses' evidence on the allegations of forgery and falsification amounted to hearsay evidence. 7. Allegations of forgery and falsification can only be proved by tendering two sets of documents, that is, one that is genuine and the other that is false or fake. 8. That the allegation of forgery against the third respondent by the appellant is a criminal offense, and the standard of proof required is beyond reasonable doubt. 9. That the maker of exhibit R2 is the University of Ibadan, and RW1 confirmed that exhibit R2 is genuine. 10. That a calm review of the totality of the evidence before the trial tribunal will reveal that the errors contained in the affidavit of loss of the original document becomes inconsequential, as the document itself has shown the date the certificate was issued. 11. The respondent said that it is right that in a claim for declaration, as in the instant case, the onus is on the plaintiff to establish his claim upon the strength of his own case and not upon the weakness of the case of the defendant. That the plaintiff must satisfy the court that upon pleadings and cogent and credible evidence adduced by him is entitled to declaration of rights in his favor. 12. The respondents agree with the position of the trial tribunal on his finding on page 3348, volume 5, of the record, which was not appealed against, that we are also of the view that Exhibit A6, that is affidavit of his loss of documents, having not been relied upon in 2020 election, cannot in any way aid the petitioner's case in proof of the third respondents in false information making him unqualified to contest said election, and we so hold. And finally, 13, that the tribunal subsequently found our position from the foregoing is that based on evidence before the tribunal, the petitioners have not been able to prove that the third respondents have presented as forged or false certificate to the first respondent. First, having put forward a definition of forgery by reference to the Black's Law Dictionary, 8th edition, in my resolution of issue 2, I adopt my said resolution of appellants. I set my said resolution to appellants issues 5 and 6. The offense of forgery is if a person makes a false instrument with the intention that he or another will use it to induce somebody to accept it as genuine, and by reason of so accepting it, to do or not to do some act to his own or any other person's prejudice. An intention that the instrument should be accepted as genuine is not sufficient. There must also be an intention to induce the recipient to act or need to act to his own or another's prejudice. Some cases are there. It is tried that an allegation of forgery, even in a civil matter, as in the instant case, must be proved beyond reasonable doubt. In this case, beyond the patent lack of credibility of appellant's witnesses as catalogued by the counsel for the respondents, the production of Exhibit R2 totally negates the intent of fraud, which is the essential evidence of forgery. This is because the basis of the allegation was the genuineness or otherwise of Exhibit R2. By the same token, the allegation of false information on the basis of contradictions between Exhibit R2 and A6 fizzles into being inconsequential. The reason being that the allegation of false information, as in the case of forgery, requires an intention to deceive another from the falsity of such claims. Perhaps the appellants took with levity the entire idea of the ultimate body of proof, which is on the party who alleges the affirmative, in this case, the appellants. This burden becomes heavy on the appellants because whether in civil or criminal proceedings, it will not take into account the weaknesses in the defendant's case. In all the circumstances, I agree with the tribunal, first, that we are also of the view that Exhibit A6, that is affidavit of his loss of documents, having not been relied upon in 2020 election, cannot in any way aid the petitioner's case in proof of the fact that the third respondent gave false information, making him unqualified to contend the said election, and we so hold. And also that still on the tribunal, our position from the foregoing is that based on evidence before the tribunal, the petitioners have not been able to prove that the third respondent has presented as forged or false certificate to the first respondent. Issues 5 and 6 are resolved against the appellants. On issue 7, learned counsel for the appellant submitted. Thank you. On issue 7, learned counsel for the appellant submitted that the trial tribunal had the law when it held that the circumstance of this case that the third respondent had been educated up to at least school certificate level or its equivalent. He submitted that the third respondent himself stated that he did not attend any primary school in the form EC9, exhibits A4 and A17. That was futile for the tribunal to have relied on exhibit R17 tendered by RW2 to conclude that the third respondent actually attended primary school at all. He submitted that the hands of RW2 exhibit R17 for documentary AIP evidence. He submitted an exhibit A3, which is the form ZF001, submitted by the third respondent to in 2016. Column 3 of that form, item 2, which deals with secondary school. The third respondent claimed to have attended secondary school only 4 years, from 1969 to 1973. That even though the third respondent tendered exhibit R18, the secondary school certificate, which was issued in June 73, appellate counsel nevertheless submitted that it is impossible to have attended secondary school for a period not less than 5 years. He noted that the trial tribunal found that the third respondent not only relied on Exhibit R17, but also on R18 around 19 in establishing that is advanced up to secondary school certificate level, and that the third respondent had not violated Section 177D of the Constitution of the Federal Republic of Nigeria. He ever insisted that the third respondent by his own oath never attended the primary school, and that a person who had incomplete secondary education cannot be qualified as a person who has been educated up to at least school certificate level and to be qualified to contest the disputed election. On issue 7, the respondent submitted that there is nowhere in the record of appeal before this court where the third respondent admitted he never attended any primary school. The mere fact that the third respondent did not complete the said column C of the form EC9 does not by any stretch of argument mean the admission of not attending primary school or educated up to school certificate level or its equivalent. Respondents added that the evidence of RW2 during cross-examination was that the mistake that led to the allegation of forgery was made by RW2 and never by third respondent himself, and that RW2 is competent to give evidence in defense of the allegation. Still on issue 7, the respondents submitted that the original copies of the academic certificates of the third respondent, which were admitted as R2, R17, R18, and R19, coupled with the oral testimony of RW2, established the fact that the third respondent is educated up to school certificate level. The respondents added that the said exhibits are also not listed in paragraph 1.24 of the appellant's brief as those objected to by the appellants at the tribunal, that the finding of tribunal cannot thus be impugned on grounds of consideration of wrongfully admitted documents. In deciding appellant, I have no doubt in my mind that the consideration for qualification under Section 177D of the Constitution of the Federal Republic of Nigeria as amended does not in the or misfilling of forms, as would seem to be suggested by the learned counsel for the appellant, but whether indeed on a consideration of the totality of evidence offered by the respondent could be said, the respondent could be said to be educated up to at least school certificate level or its equivalent. Clearly, the evidence of RW2, coupled with the fact that exhibits R2, R17, R18, and R19 were not impugned, show that the tribunal was not in error, was not in noting that the third respondent has been educated up to the level of school certificate or its equivalent. Issue 7 is resolved against the appellants. On issue 8, learned counsel for the appellant submitted that the evidence placed before the tribunal was clearly overwhelming to the effect that the third respondent participated in the primary election process of the All Progressive Congress, APC, before he jumped into the second respondent to contest the election under the platform of the second respondent. He referred to exhibits A5, A7, A8, and R23, which he said were tendered in proof of double nomination of the third respondent. He added that the third respondent did not deny the fact that he participated in the primary election process of the All Progressive Congress, APC. He referred to the provision of Section 37 of the Electoral Act 2010 as amended and submitted that as the law stands, no single individual is allowed to seek the nomination of different political parties in respect of the same elective office and in respect of the same election. He referred to cases. He submitted that the opinion expressed on the issue in the case of APC and Mary is obiter, as the issue of going to another political party was not an issue in the case. He urged us to hold the third respondent to seek double nomination. Nomination is therefore void. In response to appellants in the respondents also refer to the provision of Section 37 nomination. In particular, the word nomination was defined through the case of AP as follows. I quote, nomination is part of the process of electing a candidate for election to public office. In the context of election for public office, a candidate who has been selected to represent or is endorsed by a political party is said to be the party's nominee. The process of selection may be based on one or more primary elections or by means of a political party's convention or caucus, according to the rules of the party and any other applicable laws. So, a nomination exercise, when completed, stands apart and is distinct from the participation of the nominee from the election. Nomination or substitution of a candidate is complete the moment INEC receives the necessary documents affecting say from political parties within the matter. The respondent defined the word primaries through Section 156 of the Electoral Act to mean an intra-party election by voters of a given political party to nominate candidates for elective office in accordance with political parties' constitution and the law. The respondents also defined the word double as used in Advanced English Dictionary online as two together, or as defined dictionary 8th edition combined. From the above background, respondents submitted first that is not a true reflection of the evidence that the third respondent did not deny the allegation that he participated in the primary election of the All Progressive Congress APC, that the evidence of the third respondent severed all ties and relationship with APC on 16 June 2020 by resignation of his membership of APC. See Exhibit R20, about a week before the APC conducted their primary election to nominate their candidate for the said governorship election of 19 September 20. The respondent also tendered as Exhibit R21, the report of the APC primary election held on 22 June 2020, wherein the names of the contenders that participated in the party primary election was stated. The respondent insisted that the contention by the appellant's petitioners that since the third respondent had previously expressed interest to contest the primary election of APC before it was screened out and disqualified from the exercise, he cannot subsequently seek to contest the governorship election primary of the second respondent is a misconception and misunderstanding of the purport of Section 37 of the Electoral Act 2010 as amended. In deciding appellants issue 8, I do agree with the counsel to the respondents and trial tribunal that the decision of the third respondent to seek for nomination under the platform of the second respondent, PDP, after he was disqualified from participating in the primaries of APC at the screening stage is in consonance with the admonition of the Supreme Court in APC and Leary. In other words, that was Roosevelt GSC. I quote, before a member of the party is cleared, the party has the power to disqualify the member and is answerable to no one, including the court. A dissatisfied member's remedy to leave the party and seek his political ambitions somewhere elsewhere. Per Roosevelt GSC in APC and Leary. Finally, I agree with the trial tribunal that in the circumstances of this case, the third respondent was not guilty of double nomination, as MD said in Section 37 of the Electoral Act 2010 as amended. Issue 8 is resolved against the appellants. The appellants in this appeal nominated 8 issues. Issue 4, based on ground 6 of the appellant's notice of appeal, was discountenanced as the complaint in ground 6 was based on a non-appealable obiter dictum of the tribunal. All the other issues formulated for determination of the appeal by the appellants were resolved against the appellants. In consequence, this appeal is devoid of merit and is accordingly dismissed. The judgment of the Edo State Governorship Election Petition Tribunal, Kora, Justice Yunus Amusa, Chairman, says Y. Abubakar, Member 1, O.O. Stanley 2, delivered on 29 March 21 in petition number 01-2020 is hereby affirmed. Parties to this appeal are to bear their respective courts. Thank you very much. My learned brothers, Umbaba, JCA, Onyemenam, JCA, Amina Wambai, JCA, and Umar, JCA, were all on this panel with me, and they all agree with the judgment just read.
As the court pleases.
Thank you. Can we have 1A register?
My lord.
1A.
Yes, my lord. The second judgment on the list, CA/B/EPT/gov/01A/2021. Godwin Norelase Obaseki. And Action Democratic Party ADP. Iboy Lucky Emmanuel. Independent National Electoral Commission INEC. People's Democratic Party. All Progressive Congress APC. Andrew Osagi Ize Iyamu. My lords, parties are absent.
Just a minute, gentlemen. Now, this is the judgment in 01A was prepared by my humble self, and I will read. This court appeal is filed by Godwin. Yes?
My Lord, appearances.
Oh, forgive me. Thank you, my Lord. Appearances. Appearances, please.
My Lord, Ken Mosier.
Yes. Ken Mosier.
For the cross appellant.
For the cross appellant.
My Lord, O Jolawo SAN is with me, my Lord.
With O Jolawo SAN.
Yes, ma'am.
Yes, we are with you.
Respectfully, my Lord.
Yes.
H.O. Peter for the appellant.
Please say it again.
For the who? This cross appellant.
For the cross appellant.
Who is for the cross appellant?
Mosier is for the cross appellant.
Yes,
Yes.
So Mosier is for the cross appellant.
Mosier and Jolawo.
So, who spoke now?
Yes.
H.O. Peter for the appellant.
No appellant here.
Who are you as a cross respondent?
Cross respondent.
Which of the cross respondents? You know who you are appearing for.
It's for Andrew Osage Zeyamu.
It's not a party in the trust.
Your name again.
H.O. Peter.
H.O. Peter.
Yes, my Lord.
My Lord, Size Yamo is not a party in the cross appeal. Your Lordship gave a ruling allowing us to disengage them, Size Yamo and APC, so they are not parties to the cross appeal.
So H.O. Peter is not appearing for anybody?
Not in this appeal, my Lord.
My Lord, we are for the first cross respondent. First and second cross respondent.
ADP and Lucky Emmanuel.
Yes, my Lord.
How did they get the practice in 01?
They didn't say. You know, it was just in case. If you don't walk, you go after the other.
So where are we?
Yes. Are we hearing ourselves now? Gentlemen, I've recorded Kemosia for the cross appellant.
Yes, my lord.
Yes. Who else?
H.O. Peter.
H.O. Peter.
Yes, my lord. For
For
the
whom?
second cross respondent.
You are for first and second respondent.
Yes, my
Please
lord.
spell your name again for the first and second.
H.O.
H.O.
H.O. H for happiness.
H.O. What's
Yes,
the
my lord.
surname?
Peter. Peter.
Peter. Okay. For the
Yes,
first and second womb,
cross
cross
respondent.
respondent. Thank you.
Yes, my lord.
Cross respondents. Who else is on the screen?
May it please my noble Lord.
Yes.
My name is Kevin Ugiagbe.
Yes, Calvin Ugiagbe.
For the third cross respondent.
Thank you. For the third cross respondent, I think that's about all.
Hey, please, my lord.
Yes.
My name is Adetunji Oyeyipo.
Adetunji Oyeyipo, SAN.
Yes.
Just a minute.
Yes.
Adetunji Oyeyipo, SAN.
Thank you. Appearing with me is my learned brother, Rotimi Ogunese.
With Rotimi Ogunese.
Yes.
SAN.
Yes, sir.
You are for the
first respondent.
For the
first respondent. First.
Okay, for the first respondent. First what?
Fourth respondent. Four.
Number 4.
Yes, sir. Number
Fourth
4.
cross respondent.
Yes, sir.
Fourth cross respondent.
Fourth cross respondent.
Okay. Thank you. Now, the judgment in 01A was prepared by my humble self, and this is the judgment. This cross appeal is filed by Godwin Ogadese Obas. Huh? You said? Huh? Yes, someone said something.
I think my Lord is echoing.
This appeal is filed by Godwin Ogagese of Baseki, the third respondent in appeal number CA/BEPT/Governor 01/2021. It is against the part of the judgment delivered on 29/3/2021 in petition number EPT Governor 01/2020, Action Democratic Party and another, and INEC and 4 others. The cross appellant is dissatisfied with the part of the judgment where after holding that the cross appellant third respondent at the tribunal challenged to the local standard of the second respondent, second petitioner at the tribunal to present the petition is in order, and that the challenge to his qualification based on age is also a post-election matter. The tribunal proceeded to hold that the manner the issue was presented in the cross appellant's reply to the petition does not vest the tribunal with jurisdiction to consider same on the grounds that the issue was not raised as a prayer in the said reply of the cross appellant. That the tribunal also held that it could have been taken up as a pre-election matter. Are we hearing ourselves?
Yes, my Lord.
Yes, my Lord.
Agreed by the above decision, the cross appellant filed a notice of cross appeal on the 18th day of April 2021, and later by leave of this court, filed an amended notice of appeal. The parties exchanged briefs of argument on the cross appeal. The cross appellant's brief of argument in appeal number 01A 2021 was settled by Justin Igiebo, Esquire, Ikide Iyelua, Esquire of counsel to the first and second cross respondents, prepared cross respondents' brief of argument to the cross appeal. Cross appellants filed a reply brief. The cross respondents filed a notice of preliminary objection to the cross appeal, to which A, this honorable court has no jurisdiction to entertain this cross appeal, as the lower court never entertained the issue of local standard, which was not decided upon by the tribunal within the 180 days period allowed by section 285(6) of the Constitution to entertain election petitions. B, the 180 days window having lapsed without any decision on the issue, the lower tribunal no longer has jurisdiction to entertain that issue. And these honorable courts cannot determine that issue, which was never decided upon by the lower tribunal. And C, the cross appellant, without an order of court, has amended the parties in the brief of argument by deleting some of the parties. On A and B above, respondents' counsel submitted that an appeal is a continuation of the case before the trial court, and that an election tribunal shall deliver its judgment within 180 days from the date of filing of the petition. He submitted that since the tribunal did not make any finding or give any decision on the issue of local standard and the 180 days to determine the issue has lapsed, this court has no jurisdiction to entertain the sole issue in this cross appeal, On C, learned counsel to the cross respondent submitted that is noticeable that the notice of cross appeal and the records of appeal have 6 respondents. But on the brief of arguments are effect, he submitted that the cross appellant's brief is therefore defective and not to be struck out. On A and B of the cross respondents of preliminary objection, I do not have, there was no decision by the trial tribunal on the issue of local standard. The decline of jurisdiction on the issue of local standard of the second cross respondent after holding that is also a post-election matter. On the basis, I quote, that the third respondent did not make any prayers in the said reply in respect of the second petitioner is in itself a decision. A decision not to decide an issue is an appellable decision. The grounds A and B of the cross-respondent preliminary objection therefore lacks merit. The cross-respondent's C seems to be overtaken by events. On the whole, the cross-respondent preliminary objection fails and is accordingly dismissed. Learned counsel for the cross appellant nominated only one issue for the determination of the cross appeal. It is, I quote, whether the tribunal was right in deciding that the cross appellant should have either filed a pre-election matter or included a prayer in his reply on the issue of the second respondent's non-qualification for want of compliance with section 177B of the Constitution before the tribunal will be vested with jurisdiction to consider and determine the point that he lacked the requisite standing to join in initiating the petition. End of quote. On the said sole issue, learned counsel for the cross respondent, cross appellant, referred to Roye and Governor of Imo State, Bakari and Ajosi Adiogu, to define local standard as the legal capacity of a party to institute an action in the court of law, and that local standard being a threshold issue, there is no prescribed manner by which the issue may be raised. He submitted that the issue of local standard was properly raised by the cross appellant in his reply to the petition in paragraph 2 to 7 of pages 2132 to 22 of volume 4 of the records of appeal, and was therefore properly raised as required by the rules. So 2234. Okay. On this, cross appellant's counsel referred to the case of Bisu and Ajilowura. He submitted that in any case, there have been no appeal against the finding of the tribunal that it was in order for the cross appellant to raise the issue as he did. That point is not open to contestation in this appeal. Counsel to the cross appellant referred to the provision of paragraph 12.5 of the first schedule to the Electoral Act 2010 as amended, and submitted that the rule contemplates that such objection is to be raised in the pleading, and not by any prayer in the cross appellant's reply to the cross respondent. He submitted that a cursory look at paragraph 2, 3, 4, 6, and 7 of the cross appellant's reply will reveal that the cross appellant copiously pleaded the facts required to challenge the second cross respondent, being an underage person. At the time, he contested the election into the office of the governor of Edo State. The cross appellant contended in his reply that based on the cross respondent's age, as could be seen on his West African senior certificate issued in June 2007, which are all part of the second respondent's form EC9, affidavit of personal particulars, tendered as part of Exhibit R16 at the tribunal. His date of birth was clearly stated as 12th of May, 1990, which put his age at 30 years at the ministerial term of the election. The West African Examination Council Senior School Certification of June 2007, and the voter's card, respectively, of the second cross respondent, where his date of birth was said at 12/5/90, 12/5/90, at pages 2158 to 2 and 2159 of volume 4 of the records of appeal. These, according to cross appellants, offends the provision of section 177B of the 1999 Constitution, which fixed the minimum age for the candidate contesting for the office of governor of a state at 35 years. Counsel for the cross appellant further submitted that the second cross respondent's only response to the objection of the cross appellant was his self-declared affidavit of correction of date of birth dated 18/6/2019, and his statutory declaration of age also dated 18/6/2019, which were respectively admitted as exhibits A19 and A20 at the tribunal. Counsel for the cross appellant submitted that a person cannot depose to an affidavit to state when he was born, that also explains his refusal or disinclination towards giving evidence at the hearing of the petition to avoid being cross-examined on the effects of the said evidence. He submitted that the cross appellant, having raised in his pleadings and argued same in his final written address, the tribunal had the jurisdiction to consider same. The cross appellant said counsel cannot validly raise any prayer in his reply to vest the tribunal with jurisdiction to consider same. That once it was raised, the tribunal had the virus to entertain and rule on it. He submitted further that not being a cross petition, no prayer can be validly raised in a reply to a petition. That's sufficient when same is raised in the pleadings. He referred to section 16 of the Court of Appeal Act and not just to set aside the decision of the tribunal that it had no jurisdiction to consider the issue of lack of petition of requisite standing to present an election petition made against the second respondent by the cross appellant, and the further holding that the issue has no significant effect on the merits of the petition. Finally, he orders to make a firm determination that the cross respondent lacked the local standing to represent or join the presentation of the petition, and finally to make a firm determination that the petition is not competent on that score and dismiss him. The first and second cross respondents also nominated a sole issue for the determination of the cross appeal. It is whether the lower tribunal was right in declining jurisdiction in respect of the issue raised by the cross appeal. The cross respondent submitted that the local standing in an election position is statutorily determined by the participation of a candidate in an election and not by his age or any pre-election qualification to the candidate's participation in an election. Second, the cross respondent submitted that in this case, the statement of claim is the petition itself and is the document to be considered in order to determine whether the petitioner cross respondent has the local standard to present his petition. He referred to cases to show that the law is now established beyond argument that for purpose of determining local standard, it is the writ of summons and the statement of claim that must be looked at, and no other process relevant for this purpose. Third, the cross respondent submitted that having joined issues with the third respondent cross appellant on the question of the age of the second cross respondent, the cross appellant has a duty to prove his claim that the second cross appellant was underage, which evidence the cross appellant failed to produce. He submitted that the allegation of the cross appellant boils down to saying that the second cross respondent falsified affidavits and made false representation. That all these are criminal allegations which the court appellant was bound to prove beyond reasonable doubt. He submitted further that RW2, who witnessed for the third respondent, court appellant, did not state whether it's older or younger than the second respondent, or that he, RW2, was there when the second court respondent was born, and to have knowledge of his birth. He concluded that the court appellant cannot dispute the age of the court respondent with him, and that the first and second court respondent had the local standard to present the election. I do agree on the sole issue nominated for determination of this court appeal that the first and second respondents had the requisite local standard to present the said petition. This is not merely for the reason, as pointed out by the cross respondent, that local standard in an election petition is statutory, as stated in section 137.1 of the Electoral Act 2010 as amended, but also, and perhaps importantly, for the fact that the allegations of inconsistencies and false information presented by RW2 as to the age of the second court respondent does not fix or prove the age of the second court respondent to be 30 years of age at the time of the election. Incidentally, it was the cross appellant who referred to the decision of the Court of Appeal, Patobi JCA, as it then was in the case of Aguasim and Ejwaroye, to the effect that in law, a person's age could be proved either by the presentation of a birth certificate in court or by evidence of a person who saw the birth or had knowledge of the birth. This must be somebody who is older than the person whose age is determined by the court. Furthermore, the adverse in the reply of the third respondent cross appellant as to the false information by the second cross respondent as to his age are at best and truly pre-election issues, of which the cross appellant would have pursued in the High Court under section 31 of 5 and 6 of the Electoral Act 2010 as amended. There was no proof of the second cross respondent's age by the cross appellant. The first and second respondents had local standard to present the petition. The only issue in the court appeal is resolved against the court appellant. The court appeal lacks merit and accordingly dismissed. Parties to the court appeal are to bear their respective costs. My learned brothers, my learned brothers, Mbaba JCA, Oyebenam JCA, Amina Wamba JCA, and Numa JCA were with me, and they agree with the decision, the judgment just read. Thank you. Thank you very much. Well, now we go to O1B. O1B. Registrar. O1B.
Yes, my lord. Number 3 on the list. CA/B/ETT/gov/O1B/2021. Andrew Osage Izeyamu and Action Democratic Party, ADP, Iboe Lucky Emmanuel, Independent National Electoral Commission, INEC, People's Democratic Party, Godwin Norerase Obaseki, All Progressive Congress, APC. My lords, parties are absent.
Parties are absent.
Yes, my lord.
Appearances.
May it please, my lord.
Yes.
AI Osaenhoi.
Osaenhoi. Okay.
Yes,
let me record you. AI
Osaenhoi.
Osaenhoi. Yes.
Appear, my lord.
Yes. For the appellant.
Yes, ma'am.
Thank you.
Thank you, ma'am.
Yes. On the other side. Yes. Yes. Respond.
First and second.
It does not. It does not refer to candidates or their political parties who lost an election. The section does not envisage a loser of an election being a necessary party to be joined as a respondent to an election petition filed by another loser. Only the winner of an election and the statutory body that conducted the election or its staff or other person who participated in the conduct of an election are the necessary and statutory respondents to an election petition or appeal. This point was made by wife for JAC in Buhari Yusuf, and I'll skip what he said. Put differently and succinctly, only the winner of an election and the statutory body or its staff or other person who participated in the conduct of an election are necessary respondents to an election petition or appeal. The law only envisages an election petition to be between a loser as the petitioner and a winner as the respondent, and not between two or more losers. It is an elementary principle of interpretation of statutory provisions that where a statute expressly mentions things or persons, it is the intention of the legislature that those not mentioned are intended to be excluded. In the case of APC against PDP, which is later in time than the Buhari's case, which the Learned Appellants Council relied upon, the Supreme Court by Galatima and JSC made it clear that there are only two classes of respondents in an election petition.
As for the woman.
Yes, I have gone through the case of Buhari and Yusuf, heavily relied upon by the Land Appellants Council. The facts and the circumstances of the present appeal are different from those in Buhari Yusuf. It is now firmly settled that each case is an authority only for what it decides and nothing more. Authorities cannot be applied across board in total disregard to the peculiar facts in which they are decided. Each case must be considered in the light of its own peculiar facts and circumstances. In the Buhari's case, unlike in the case at hand, none of the co-respondents in the Buhari's case sought to be struck out, made any relief, or applied for any relief from the court in their reply to the petition to nullify the election of the principal respondent whose election and return was being challenged by the petitioners, and a further in the case at hand, the appellant having prayed the trial tribunal to disqualify the fifth respondent who won the election and was the candidate duly returned by the third respondent, and also further prayed that he be declared the duly elected candidate at the election. It was very much the business, and I must add, the duty of the fifth respondent to apply that the appellant's name and his reply to the petition be struck out. It was also the business of the fourth respondent, the political party of the fifth respondent, to apply that the appellant be struck out of the petition. Unquestionably, the decision in Buhari against Yusuf, wherein the Supreme Court was quoted to have held that it is not the business of a co-respondent to apply that the name of another respondent be struck out, does not apply to the peculiar facts and the circumstances of this case. In the said appellant's reply to the petition, I think in paragraph 26, the reliefs where he relieves makes him a mini petitioner. It is necessary to now turn to section 133(1) of the Electoral Act to know how to bring an election petition, and I quoted the provision. So the only way the conduct of an election or the return of a candidate an election can be challenged is by an election petition duly filed before a duly constituted election petition tribunal or court in accordance with section 285 of the Constitution and section 133 of the Electoral Act, and in the manner set out in the first schedule to the Electoral Act. The election petition must be presented in conformity with the relevant provisions of the first schedule. No other method of complaint against the conduct of an election or the return of a candidate other than by an election petition presented before an election petition tribunal or court is acceptable by the Constitution and the Electoral Act. Section 285(1) of the Constitution is very emphatic on this point, just as section 1331, subsection 1 of the Electoral Act is. The appellant herein did not file any election petition before the tribunal to question the election of the 29th 9/2020, or the return of the fifth respondent made by the third respondent from that election. The appellant only seeks to write through the back of the first and second respondent who filed an election petition to do what he would have done or sought if he had filed an election petition, forgetting that he was only a respondent to the petition. The traditional duty or role of a respondent at the tribunal at a trial court is to defend the action and on appeal to defend the judgment appealed against. It is not for a respondent defendant at the trial court to seek declaratory reliefs except through a counterclaim, and on appeal, it is not for a respondent who has not cross-appealed or filed a notice of contention to criticize or attack the judgment of the lower court. His duty is to defend the judgment. It is indeed strange that the appellant as a respondent to the petition, rather than defend the action or seek to be disjoined from the petition, will turn into a pseudo petitioner by fighting his own case through another person's petition. It is a novel adventure, and most surely not within the contemplation of the Constitution and the Electoral Act that a respondent to an election petition will turn into a petitioner and seek a declaration within another person's petition to be declared the winner of an election without filing an election petition. This novelty is very feeble and is one that cannot survive the incubation process to see the light of day. Except words have changed their meanings, and I believe they have not, or the learned counsel to the appellant expects the impossible of squeezing water out of the rock. No amount of elastic interpretation can be given to paragraph 12 of the first schedule or the entire Electoral Act to permit a co-respondent in an election petition turn is a respondent's reply to an election petition. The purpose of a respondent reply to the petition is different from the purpose of a petition. They do not serve the same purpose and therefore not interchangeable. A party who does not file an election petition cannot turn its reply to a petition as an election petition and seek through the reply reliefs inter alia to be declared the winner of an election or overturn the return of the candidate that he did not challenge in a manner known and acceptable by law. The only option for the appellant is to pursue his relief was to file his own election petition. That is the only medium and the vehicle through which a party aggrieved with the conduct of an election or the return of a candidate to an election can challenge same and seek redress from the election tribunal or court. He cannot, through another person's petition, seek to be declared the winner of the election. The other option, if not interested in challenging the election or the return of the fifth respondent, was to apply to be joined from the petition or at least remain aloof as an unnecessary and undesirable respondent to the petition. The position of the appellant can be likened to that of a snake that never digs a hole but assumes the right of ownership and occupation of a hole dug by others. The appellant cannot do that. He cannot come through the back door to get what he would have not gotten through the proper door. Again, let me, for the emptieth time, make it clear that for the appellant to seek the reliefs he prayed for at paragraph 26 of his reply, he has to file an election petition in compliance with the Constitution of the Federal Republic of Nigeria and the Electoral Act, and in accordance with the procedure set out in the first schedule to Electoral Act. Any other method or procedure other than this is unknown to law. In summation, the lower court was right in striking out the names of the appellant and his political party, the sixth respondent, from the election petition filed by the first and second respondents for being unnecessary respondents wrongly joined in the petition, which the tribunal could have done even suo motu. The issue is therefore resolved against the appellant. Having so resolved this issue against the appellant, the consideration of the second issue becomes unnecessary. The effect is that there is no merit in this appeal. It is accordingly dismissed, and the judgment of the lower court is affirmed. Parties shall bear their cost. This is the judgment of the court. My brothers, the PJ, my brother, Honorable Justice Mbaba.
On this panel, and I agree with the judgment just read. My learned brothers, Mbaba, Oyemena, Umar, JJCA, will in turn reach their judgments.
Okay, he said they will also So they will also read their judgment that they agree. Yeah, so that was understood. Did I take up to 40 minutes?
Said I sat on this panel and I agree with the judgment just read. My learned brother Sumbaba Onyemina.
Having challenges.
That's it.
They agree with me. Since I said that they agree with me, so it means
That's Mbaba is in a way. Oh, okay. That will even make it more difficult.
it's coming now.
I will have stayed in the division. He would have stayed in his division instead of home. Remember? Is in New York? Mbaba went to New York.
My lord. Well, we are on now.
I agree.
Thank you, Justice Onyemena.
I also agree with the decision that's just been delivered.
Thank you, Justice Umar.
I also agree.
Justice Umar.
I have also agreed with the judgment delivered by my learned brother, one by JCA. I entirely agree with the reasoning and conclusions.
Thank you.
Let's call please.
Thank you. Registrar, call O2, please. Registrar, O2. Registrar.
That's from there. That's Benin.
I just called the guy that's working with my
Okay.
So she said that they're having some chapter.
My lords, parties
Yes,
are absent. Parties are absent.
have you called the case?
Yes, man. Let me go again.
Take it again. Take it again. Yes.
PA/B/EPT/gov/02/2021.
Yes.
Action People's Party APP.
Yes.
And Godwin Obaseki.
Yes.
People's Democratic Party PDP.
Yes.
Independent National Electoral Commission INEC.
Yes.
My lords, parties are absent.
Thank you. Parties are absent.
Yes, my lord.
Appearances, please. Appearances. Yes. Huh? For the appellants. Shebu Fiki for the appellants.
Can you come
Thank
again?
you.
Appellant counsel.
Shebu Fiki for the appellants. Yes. Who else? On the other side.
My Lord, Ken Mozia.
Oh, yes. Ken Mozia SAN.
And O Jolawo SAN.
And O Jolawo SAN.
We are being first respondent.
Jolawo for the Etiaba?
Yes, my lord.
Your first name? Your initials?
E for Ed, C for Christian.
Is it Emeka Etiaba?
Oh, the younger brother.
The
Etiaba. E-T-I-A-B.
Second respondent, and I'm telling with me. Yes,
are you SAN too?
Yes, my lord.
Your SAN, forgive me. Thank you. Congratulations. Etiaba SAN with whom?
Who got DM?
You spell that name.
Who got them? E-H-U.
E-H-U, yes.
A-W-U.
A-W-U.
G.
Oh, Z-I-E-N. Okay. Ooh, okay. Thank you. Thank you. You are for number two.
Yes,
for the second respondent.
Yes,
for the second respondent. Okay, thank you. Number 3, third respondent.
This is my noble lord.
Okay.
My name is Alex Izion.
Alex Izion.
My learned friend BK Abu appears with me for the third respondent.
Thank you very much. BK Abu for the third respondent. For the third, number 3, for the third respondent. Yes. Who else? Who else, please? I think we are done. We are done. The judgment in this case was prepared by my learned brother Mbaba JCA. He will read the judgment. Mbaba JCA, Justice Mbaba.
Thank you, my Lord.
Yes.
My Lord, please, you'll permit me, after taking the introductions, to give some summary and then go to conclusion.
Please go ahead. Go ahead with your stuff.
This appeal emanated from the decision of the Edo State Governorship Election Petition Tribunal delivered on 29 March 2021, whereof the Honorable Tribunal struck out and or dismissed the petition for being incompetent or for not being proved. Appellant's hearing was the petitioner, being a political party, complaining against the election and return of the first respondent, who was sponsored by the second respondent at the election, as pronounced by the third respondent, which conducted the election. At the tribunal, appellant as petitioner had prayed as follows. 1, that it may be determined that the Edo State governorship election held on 19 September 2020 be nullified by reason of the unlawful exclusion of the validly nominated candidates of the petitioner from the election. 2, that it may be determined that a fresh governorship election be conducted for the office of governor of Edo State, wherein the validly nominated candidates of the petitioner would be included or represented on the relevant result sheets and on all other documents for the said election. The respondents had filed preliminary objections to the petition, challenging competence of the petition. The first respondents and the third respondents had filed preliminary objection to the said petition, which the tribunal considered, and at the end of the consideration, the tribunal held in favor of the objections. Tribunal said on whether the petitioner has the legal standard to present this petition, we find that the petitioner, being a political party, has the legal standard to institute the petition. The status of the petition is what we are expected to determine in this application. We therefore hold that petitioner has legal standards. Tribunal continued on whether the substance of the petition is not a pre-election matter, which this honorable tribunal lacks jurisdiction to entertain. The grounds of this petition fall squarely within the ambit of pre-election matters. From what the court have defined as pre-election matters, the grounds of this petition are squarely founded on events, issues, and matters that occurred before the actual holding of the election. And that is why petitioner filed at the Federal High Court, Abuja. We therefore hold that the petition falls within the ambit of pre-election matter. Based on that findings of the tribunal struck out the petition and also decided the same way in repetition in respect of the preliminary objection that was brought by the third respondent. But apart from striking out the petition on the basis of the success of the preliminary objection, the tribunal went ahead to determine the petition on the merits and dismissed the same, saying that the petition was not proved. Appellants filed this appeal to challenge that decision of the tribunal, striking out the petition and also dismissing it. Appellants filed its brief of argument on 2nd of May 2021, and there still 6 issues for the termination of the appeal. I have reproduced the 6 issues in this judgment, and parties and counsel will read it when they get the judgment. The first respondents also distilled review and resolve the issues that were the issues by the party appellant and the respondent. I think the real issue for the termination of this appeal is whether the tribunal was right to hold that the petition related to pre-election matter and so struck out paragraphs 11 to 9, 11 to 20, 21, 22, 23, 25, 26, 28, 29, 30, 31, and 33 of the petition for incompetence for relating to pre-election matter, and finally dismiss the petition. I think the issue for determination of this appeal, whether the tribunal was right to strike out the petition for incompetence, the same being founded on pre-election matter, which was pending in the Federal High Court before the election, was properly considered by the tribunal. Tribunal had held. I have reproduced the germane parts of the decision of the tribunal in this issues and matters that occurred before the actual holding of the election, as clearly admitted by the appellant, as shown in the suit number of July 2020, and pending at the Federal High Court of Abuja, even as at the 19th day of September 2020, when the governorship election was held in Edo State. The suit was taken out by the appellant against INEC, that is the earlier candidates for the office of governor Alfred Saki Oga, governorship and deputy governorship candidates respectively. But the third respondent officials refused to accept the documents on the ground that the third respondent's timetable at lapsed. Timetable to receive subscription at lapsed. With the above arguments and submission by appellants, I find it difficult to see or appreciate the need for this appeal, as it is obvious appellant was not in the contest for the election and did not contest the Edo State governorship election on 19th September 2020, as it fielded no candidate for the state election. Appellant had outstanding dispute with the third respondent on its failures to inability to field a candidate for the state election, and had initiated a pre-election to challenge the third respondent's refusal to accept its candidate. But while the state suit was pending, the election as it appears, it had no candidates for or in the election capable of being excluded withdrawal and substitution of its candidate to the third respondent, but the third respondent officials refused to accept the state document, end of quote, on grounds that the time for substitution had lapsed. Appellants clearly shows that it admits that it had no candidate at the election. Even by the case of ACN and another versus Peter and others heavily relied upon by the appellants in this appeal, the point was made that pre-election dispute contemplates actual election, which is challengeable on the ground of undue election or undue return, albeit on a specific ground or grounds, as presented by Section 140, Sub 1 and 2 of the Electoral Act to adjudication. Taking the above pronouncement as a compass, it becomes obvious that the issue of valid nomination of a candidate and unlawful exclusion from election comes squarely within the province of post-election dispute. The reason is simple. Continues. An issue of valid nomination with unlawful exclusion is one of the grounds which Section 138 sub 1 of the Electoral Act 2010, as amended, recognized and catalogued precisely in Section 1381 sub D thereof as the basis for questioning the conduct of the election in Nigeria. Unarguably, an election is invariably challenged after its conduct, not prior to its conduct. Since the issue of valid nomination and unlawful exclusion is cognizable as the ground for such a post-election challenge, it axiomatically follows that it is an issue that is determined within the jurisdictional confine of exclusion, within the jurisdictional confine of exclusion petition tribunals. It is my view that to reason that the issue of valid nomination and unlawful election is for the regular court to entertain automatically strips candidates and political parties of their right to question conduct of election on this ground. The INEC will have a field day to exclude candidates from election, end of quote. That's what the position in the case that the appellant was relying on presented. But I think the underlining words in the above statement of the law in the case of ACN and another versus Peter and others, Supra, are the words valid nomination of candidates and unlawful exclusion from election. That means there must be a premise of agreement that the political party had made a valid nomination of its candidates or candidates for the election, but the umpire, that is INEC, unlawfully excluded the said party and all its candidates from the contest. Of course, in that case, the Section 1381D of the Electoral Act 2010 as amended applies as ground for questioning the conduct of the election, namely that the petitioner or its candidate was, quote, validly nominated but was unlawfully excluded from the election. In this case, at hand, appellant had graciously disclosed and affirmed that the issue of nomination of its candidate for the election was yet to be resolved at the time of the conduct of the election on 19/9/2020. That its candidate had appellant had admitted that its candidate had voluntarily withdrawn from the election. He said in paragraph 2.2 of the brief, and I quote, on 27/2020, an official of appellant attempted to convey the notices of the withdrawal and substitution of candidates to the third respondent, but the third respondent officials refused to accept the document on the ground that by the third respondent's timetable, the last day for the substitution of candidates was 13th of July 2020. The appellant thereafter sent a letter of complaint dated 22nd July 2020, annexing all the said documents. As I said earlier, see paragraph 2.2 of the appellant's brief. The above argument appears to be a clear admission against interest by the appellant and as typified in the said suit number FHC/ABJ/CA/858/2020, taken out by appellant at the Federal High Court, Abuja, on 24th day of July 2020 to resolve the issue of nomination of candidates for the election. Thus, the issue of nomination was not resolved, not to talk of valid nomination. That suit was still pending at the Federal High Court when appellant filed the petition before the tribunal, and that, in my opinion, was an abuse of the court process. See the case of Nolim versus Nolim, citations given, and I've also reproduced the germane parts of petition in that case. See also the case of Oyeyemi and others versus Nweye, citations given, wherein the Supreme Court said, and I quote, "It is settled law that abuse of process contemplates multiplicity of suit between the same parties in regard to the same subject matter and on the same issue." I've also reproduced the ratio in the case of Ding Yadi and another versus INEC, citations given, where the Supreme Court said, and I quote, "Abuse of court is not merely an irregularity, but constitutes fundamental defects which lead to dismissal of the process, which is abusive." Other cases are cited to support that position of the law. The petition was therefore an abuse of the process, considering the pendency of suit number FHC/ABJ/CA/858/2020 on the same complaint by the petitioner. A person is said to give evidence against his interest in a suit where he makes a statement, oral or written, which is adverse to his case, and it is admissible in the proceedings as evidence against him of the truth of the fact asserted in the statement. See the case of Intra Industries Nigeria Limited versus NBC, citations given. And other cases are cited to support that position of the law about admission against interest. Thus, there is nothing in the case of appellants to show that appellant had validly nominated candidates at the election on 19/9/2020, which the third respondent unlawfully excluded. This case appears to be akin to the case of Diri versus ANDP and others 2020, citations given, where the petitioner therein sought the nullification of the declaration of appellant as the winner of the election on the ground of unlawful exclusion and for breach of section 1381D of the Electoral Act as amended. It was held that there cannot be an unlawful exclusion where there is no valid nomination. And it is for the party who alleges unlawful exclusion after valid nomination to stand election to establish that fact of valid nomination and unlawful exclusion. Of course, that case was affirmed by the Supreme Court. See also the case of APP versus INEC. Citations given. I've also reproduced the germane part of the holding of that case, still on the issue of valid nomination before you can talk about unlawful exclusion. The moment there is no valid nomination of a party to stand election, and the party cannot complain to the tribunal of unlawful exclusion. The above decision would actually be relevant to a pending suit in the Abuja Federal High Court as stated, but it is also applicable to this case at hand with respect to the fact that the issue of refusal to substitute candidate is a pre-election matter, not election tribunal matter. The trial tribunal, in my opinion, had properly articulated the position of the law in this case when it came to the conclusion that the complaints of the appellant in the petition touched on matters and issues that occurred before the election of 19/9/2020, and so were not capable of invoking the jurisdiction of the election tribunal to adjudicate on. The tribunal was therefore right to strike out the petition, and the stated paragraphs complain of for being on a pre-election matter. It was not necessary, in my opinion, for the trial tribunal to even go further to consider the petition on the merit in the circumstances. This appeal lacks merit and is accordingly dismissed. Appellant shall pay the cost of this appeal assessed at 600,000 naira to the respondents.
As God pleases.
Thank you very much. I was on this panel. Thank you, thank you. I was on the panel and I agree with the judgment just delivered by Justice Umbaba. My learned brothers, Oyemina and Umar, JJCA, Oyeminam, Wambai and Umar, JJCA will in turn deliver their judgments in this appeal. Justice Oyemina. Justice Oyemina.
I agree with the judgment that has just been delivered.
Thank you. Justice Wambai.
I agree with the judgment entirely.
Thank you. Justice Umar.
I entirely agree with the judgment just delivered by my learned brother, Justice Mbaba.
Thank you very much. That is the judgment of the Court of Appeal.
We thank your lordships.
Thank you. Registrar, can you call 03?
My lord.
03, please.
CA/B/EPT/Go/03/2021. Allied People's Movement, APN, and Independent National Electoral Commission, INEC, People's Democratic Party, PDP, Godwin N. Obaseki, Philip Shaibu. My lords, parties are absent.
Parties are absent.
Yes,
Appearances.
Please, my lord.
Yes.
AI Osaengoy.
OI Osaengoy.
Yes, my lord. AI.
Osaengoy. Yes, you are for the
appellants, my lord.
Appellants, yes. Appellants. Yes, respondents.
May it please my noble lord.
Yes.
My name is Kevin Ugiagbe.
Kelvin Ugiagbe. Yes.
Yes, my lord. My appearance is for the first respondent.
Number one respondent. For the first respondent. Thank you. Yes,
If it pleases my noble lords.
Yes.
I am Chief Chris Uche.
Chief Chris Uche.
I appear for the second respondent.
Uche, SAN for the second respondent.
And with me, my lords, is my learned friend Olakunle Lawal Esquire.
With Olakunle Lawal Esquire.
For the second respondent. We are grateful.
Number 3, third respondent.
Lord
Yes.
Mosiah.
Okay, Ken Mosiah.
Yes,
SAN.
O Jolawo SAN.
Yes. With O Jolawo SAN. With O Jolawo SAN for the third.
The third, yes, my lord.
Thank you for the third respondent. Who else, please? Yes. Number 4. Yes, number 4, if any. I think we are ready.
Niya Akitola.
Niya Akintola, Chief Niya Akintola, are you there? Are you on screen?
Samuel was there.
With Samuel what? Number 4. They are not on the screen. Okay, now we are set. The judgment in this appeal was prepared by my learned brother, Uchechukwu Onyemena. He will deliver his judgment.
As God pleases.
Yes.
Thank you, my Lord Deputy. I hope you can hear me.
Yes, they are hearing you.
Okay.
Go ahead.
Okay. I will introduce the appeal and talk to the judgment when the learned counsel get their
Thank you.
judgment.
Go ahead.
The appeal is as a result of the dissatisfaction of the appellant against the judgment of the Edo State Governorship Election Tribunal sitting in Benin, wherein the tribunal on the 29th day of March 2021 entered judgment in favor of the respondents as follows, and I quote, "In the light of the foregoing, we are of the view that from the gamut of evidence placed before this honorable tribunal, the petition, the relief sought by the petitioners, we so hold. Accordingly, we hereby hold that all the 3 issues in this petition are resolved in favor of the respondents and against the petitioner. This petition lacks merit and it is hereby dismissed." It is against this decision that the appellant has brought this appeal. After or decided by the learned counsel, senior counsel, inclusive of the appeal before it was heard, the second respondent through his counsel, learned silk, Chief Chris Uche, had a motion which was taken on the 19th of May 2021, and the ruling for that motion was reserved to be delivered along with it. Also, when the appeal was called up for hearing on the said 19th day of May 2021, the third and fourth respondents raised their preliminary objections, which were taken before the appeal. And so I will determine, or I will deliver my ruling on the motion before I go into the main appeal. The learned silk challenged some grounds of the grounds of appeal, and also asked that they be brought out for being incompetent alongside with the issues that were raised therefrom. I consider the motion and the position of the appellant and due reasonings I came to the conclusion that the application had merit and I granted it. So the issues, the grounds of appeals that were under attack by the second respondent were struck out, and also the issues raised therefrom. I also agreed with them that ground 25 of the grounds of appeal, there was no issue that was the ground, I agree with them, had been abandoned. Then the appeal was taken on the 15th, and like I said, we had preliminary objections. So in the main appeal, the four respondents raised the preliminary objection on the competence of the brief of the appellant. Argued that the appellant filed his brief outside the 10 days prescribed by the election petition and practice directions of this court. I considered the arguments on both sides. The third respondent argued that the appellant was served with the record of appeal on the 24th day of April. And so appellant's brief outside the 10th days, the appeal should be. Are you with me? Are you hearing me?
Yes, my lord.
Yes, my lord. Yeah.
Okay. Okay. So the third respondent argued that the appellant's brief was filed outside the 10 days prescribed by the law, and so it should be struck out. I looked at the did not put place before the court the affidavit of service of the court bailiff, which is the absolute proof of when the appellant was served with the record of appeal. Also, the appellant itself argued that they were served with a record on the 27th day of April, but did not also follow the bailiff's affidavit of service. Rather, there was an affidavit of service by the appellant to say when they were served. Albeit to resolve the disputes, I looked into the file of the court, and from our processes, it is glaring that the appellant was served with the record of appeal on the 27th day. And so I looked at it, I agreed with the appellant that the appellant's brief was filed within time. And so the preliminary objection of the third respondent is hereby discountenanced by me. Then respondent's preliminary objection. The fourth respondent argued that the entire grounds of appeal of the appellant are all the judgment of the court. I looked at it, I did not agree with the fourth respondent, but to the extent I had granted the application of the second respondent, I say that the preliminary objection of the fourth respondent succeeds to that extent, to the extent of the grounds of appeal, to the extent of the grounds of appeal and issues that I had motion on notice of the second respondent. So that is it with the preliminary objections.
That's complete.
I now go to the main appeal. I carefully looked at the issues raised by the appellant and the respondents all together, and I think the person that has the grounds will determine the issues adequately. And now having struck out 7 and 13 of the issues as being in okay.
Check the other one.
Can you hear me now?
Go on.
Okay, now, yeah, we can, my lord.
Can you hear me?
Yes.
Can you hear me?
Proceed.
Okay, okay,
Yes,
sorry for
my
that.
lord.
Yes. So out of the 12 issues distilled by the appellant, I will now determine the appeal based on issues 1, 2, 4, 5, 6, 7, 8, 9, and 12, having struck out the other issues. But albeit, while issues 1, 2, and 12 shall stand on their own respectively, I will recouch issues as one issue. I'll rephrase them. And at the end of the day, I will now have 4 issues to determine the appeals. And the issues are as follows. Whether the provisions of sections 97 and 98 of the Sheriffs and Civil Process Act apply to an election petition as am I back to you? Can
Right
you hear me?
now.
Yes. Sorry for the devil's work. All along, my internet was working very well.
How come it's
Issue
not working
1 is where the provision section. Can you hear me?
We can, my lord.
Yes,
Proceed.
yes.
Yes.
Okay, okay. Whether the provisions of sections 97 and 98 of the Sheriffs and Civil Process Act apply to an election petition as to make non-compliance with the provisions render election petition incompetent. 2, whether the issue of the non-qualification of the 3rd and 4th respondents whose elections were questioned under section 138 subsection of the Act 2010 as amended is a pre-election matter under section 31(5) and 6 of the Electoral Act 2010 and section 28 at the High Court and not at the trial tribunal. 3, whether the trial tribunal adequately evaluated both oral and documentary evidence of the appellants so as to breach his right to fair Okay, I think I'm back to you.
Yes, my lord.
So for the first issue, which is whether sections 97 and 98 of the Sheriffs and Civil Process Act apply to an election petition, I considered adequately section 151 of the Electoral Act, section 133, subsection 1 of the Electoral Act, paragraph 54 of the first schedule to the Electoral Act, and sections 97 and 98 of the Sheriffs and Civil Processes Act. And from these laws, I came to the conclusion that sections 97 and are you with me?
Yes, my lord.
Are you hearing me?
Yes.
Yes, my lord, we are.
Okay. Okay, I came to the conclusion that sections 97 and 98 of the Sheriffs and Civil Process Act are not applicable to election petitions. The learned trial judge was wrong to strike out the petition for incompetence on ground to comply with the provisions of section 97 and 98 of the Sheriffs and Civil Process Act. So I resolved issue 1 in favor of the appellant. Now to issue 2, whether the issues of non-qualification of the third and second respondents are pre-election matters. I considered the arguments of both, which I summarized quickly, and came to the conclusion that since the issue of non-qualification of third and fourth respondents whose elections were questioned, being complaints that they do, that's the third and fourth respondents submitted false information to the first respondent in their form EC9. I said that change was the submission of false information to first respondents in their form EC9 based on numerous Supreme Court decisions. I held that the complaint of the appellant is a pre-election matter and not a matter that should have come before the election tribunal. It's a matter that ought to have been filed, the information submitted to first respondent by the respondents, and so should have been an pre-election matter that should come on should have been brought before either the State High Court or FCT High Court or the Federal High Court. And so issue number 2 was resolved against the appellants. Now to issue number 3, together.
Yeah.
Issue number 3, whether the tribunal adequately evaluated the oral evidence before it. The argument of the appellant is that the trial tribunal did not in any way refer to their argued positions of the law they stated, and so that it did not give them fair hearing, as he did not consider their arguments. I looked at the judgment of the trial court. I have reproduced some paragraphs, some excerpts from the judgment of the trial court to show that the trial court adequately considered the appellant at the trial court. It's only that the trial court said they will not go into they will not summarize all that the appellant hearing, who was the petitioner, had presented before them by reason of time. That's a particular pattern that a judgment must be written. Nothing in the rules or in the laws a court to summarize in details the submissions or case of a party. That means that that court did not consider the submissions and the party's case before arriving at its decision. So considering everything on record, I came to the conclusion that the trial tribunal adequately considered the cases of both parties at its conclusion or decision. And so on that note, I resolved issue 3 against the appellant and in favor of the respondents.
Stop, please.
Now to issue 4, whether it said it's representation of forged certificates by a candidate for an election under section 182 subsection 1J of the 1999 Constitution, that the 3rd and 4th respondents presented forged certificate. Have you lost me?
No, we are still with you, my lord.
Yes.
We can, my lord.
You're still with me, okay. So,
yes, my lord.
In resolving this issue, quickly, I said, as I have earlier stated, in this election, civil proceedings or ordinary criminal proceedings are referred to authorities. It is the argument of the learned counsel for the appellant hearing that the election petitions are civil proceedings, and thus every proof required therein is on preponderance of evidence or balance of probability. With difference to the learned counsel, this is an erroneous conception. An allegation that presented forged certificates is firmly rooted in criminality, which must be proved beyond reasonable doubt. It is not enough to make such allegation. The party so alleging must go further to lead credible evidence to prove such allegation in accordance with the provisions of the Evidence Act. I've cited authorities to that effect. However, as I had earlier stated in this judgment, the judgments of petition number EDHA 24, Philip Oshomai Sede and another, and Philip Shaibu and 3 others, and suit number FHC/B/83/2021, Steve Sylvanus Eruaga and Shaibu and another, and the judgments in suit number EHC/B/CS/74/2020, All Progressive Congress and another against Godwin N. And 2 others as CAJ/CV/71/2022, All Progressive Congress and another against Godwin N. Obaseki and others, constitute judgment in rem on the issues of forgery of the 3rd and 4th respondents' educational certificates and qualifications to stand for election in Nigeria, and binds the whole world until set aside by a court of competent jurisdiction. This court of 2021 All Progressive Congress, and another against Godwin and Obaseki and two others, affirmed that the third and fourth respondents did not forge the certificates they submitted to the first respondents in a Edo State governorship election of October 2019, and lack the requisite competence to make any pronouncement on whether or not the said issue of forgery become academic to do so, for the fact that this court cannot, in the circumstance of the case, review its earlier judgments in rem, particularly as the appellant has not shown that he is referring to documents and certificates different from the ones challenged and pronounced upon in appeal number CA/ABJ/CV 71/2020 between All Progressive Congress and another and Godwin and Obaseki. Court cannot therefore, in the circumstance, pronounce on this issue. The said issue is accordingly struck out. Having resolved the two material issues against the appellant, I hold that the appellant's appeal lacks the required merits to sustain it. Appeal is therefore dismissed. The decision of the Edo State Governorship Election Petition Tribunal delivered on 20 March 2020/Gov/04/2020, dismissing the petition of the appellant on its merits, is hereby affirmed. I award costs of 50,000 naira in favor of the respondents, respectively, against the appellants.
As court pleases.
Thank you very much. As the court pleases. I sat on this panel and I agree with the judgment just read.
As court
Sat on this panel and I agree with the judgment just read.
As
My
court
learned
pleases.
brothers, Mbaba, JCA, Wamba, JCA, and Numa, JCA, will in turn deliver their judgments.
I too agree with the judgment just read.
As court pleases.
I also agree with the judgment just read.
I
As
also
God pleases.
agree with the judgment just read.
As court pleases.
Thank you very much.
We are grateful, my
Registrar,
Lord.
Registrar, can we have 04?
Yes, my Lord.
04, please.
TA/B/EPT/gov/04/2021. All Progressives Congress APC and Action Democratic Party ADP. Iboy Lucky Emmanuel. Independent National Electoral Commission INEC. People's Democratic Party PDP. Godwin Norerase Obaseki. Andrew Osaigi Ize Iyamu. My lords, parties are absent.
Parties are absent. 04, appearances. Appearances.
Greatest respect, my noble lords.
Yes. He who saw Esquire, you are for
the appellant.
For the appellant. Thank you. Yes, respondents. Yes.
Please, my noble lords.
Yes.
My name is Kelvin Ugiagbe.
Kelvin Ugiagbe.
For the third respondents, my lord.
For the third respondent, number 3. For the third respondent. Yes, who else?
My lords, Ken Mosier.
Ken Mosier, SAN.
O Jola SAN. For the fourth, my lord, number 4.
Okay, Jola SAN for number 4, for the fourth respondent.
Yeah.
For the fourth respondent, thank you. Who else? Yes.
May it please, my lord?
Yes.
A.I. Osarenhoi.
A.I. Osarenhoi.
For the sixth respondent.
For number 6, for the 6 respondents. Yes, that's about all. Which for number 5? Number 5 respondents. Oh, okay. It's now Obaseki is now number 4.
Number 4, yeah.
Number 4, okay. I understand. So who's number 5?
My Lord, that is Adetunji Oyeyipo.
Adetunji Oyeyipo is not on screen. Adetunji Oyeyipo, SAN.
Yes, with Rotimi Ogunweso.
With Rotimi Ogunweso.
Yes.
Rotimi Ogunweso, SAN. They are for number what?
The People's Democratic Party.
Number 5.
Huh? Number 8.
Please let us be clear on that. Oyeyipo.
Yes, my
Lord. Who is your client?
People's Democratic Party, Lord.
Is that not number 5?
I believe it's number 5. Right? It was
okay. For the 5th respondent.
Number 4.
We have to be clear.
It was number 4, my Lord.
People's Democratic Party is number 4.
So which number 5?
Number 5 is Godwin
Obaseki.
Therefore, Kenmozia. Kenmozia is for number what? Kenmozia, who is your client?
My client is Godwin Obaseki.
Okay, that's number 5, 5th respondent. And then we have Oserangai for 6. I know Oyeyipo for Oyeyipo. Who is your client, Oyeyipo?
People's Democratic Party, my lord.
That's number 4.
Number 4, yes, sir.
For the 4th respondent. It's clearer now.
My lord, I apologize. Mine should be 5, not 4.
That is Kenmozia.
Kenmozia, yes, my lord. It's
You are number 5, exactly. Someone is talking about 1st and 2nd.
1st and 2nd, yes.
Who is for 1st and 2nd?
A lot.
Okay, okay. Okay. Is he in court? Is he on screen?
No, my lord.
Okay. We was served.
Yes, my lord.
Register cancel
for 1st and 2nd respondents.
For 1st and 2nd was served.
Yes,
thank you. For 1st and 2nd respondents was served.
Yes, my lord.
Ikide Eigelua. Okay. Thank you.
Yes, my lord.
This appeal was prepared by my learned brother, Justice Zuma, and he will deliver, Justice Sadiq Umar will deliver his judgment. My Lord Umar.
Thank you, my Lord. Thank you, my Lord. PJ, I hope you are hearing me.
Yes, go ahead.
So I will try also to summarize and abbreviate the judgment so that we can save time. Now, the judgment goes as, this is an appeal against the decision of the Governorship Election Petition Tribunal sitting at Benin, delivered on the 29th day of March 2021, wherein judgment was entered against the 1st and 2nd respondents who are petitioners at the tribunal and in favor of the 4th and 5th respondents. The 1st respondent sponsored the 2nd respondent in the said election, and the 4th respondent sponsored the 5th respondent, while the appellant herein sponsored the 6th respondent. The 3rd respondent conducted the election, declared and returned the 5th respondent as the winner of the governorship election held in Edo State on the 19th day of September 2020. I'm happy with the declaration and return of the 5th respondent as the governor of Edo State. The 1st and 2nd respondent has petitioned, file an election.
My lord, may I respectfully indicate that we are not hearing your lordship?
Okay, I will take it again. Are you hearing me now?
Yes, I do now.
Okay.
I'm grateful, sir.
Okay, so I'm happy with the declaration and the return of the fifth respondent as the governor of Edo State. The first and second respondent as petitioners filed an election petition dated 5th day of October 2020, challenging the aforesaid return of the fifth respondent hearing by the third respondent as the winner of the said election. The sole ground upon which the first and second respondent petition was predicated is contained on paragraph 13A of the petition, which is stated on page 2 of my judgment. The appellant, who was also a respondent, filed his reply on the petition on the 27th day of October 2020. And in the course of hearing the petition, the third respondent in this appeal filed a preliminary objection, praying, among other reliefs, for an order striking out the names of the appellant hearing and the sixth respondent, i.e., the candidate sponsored by the appellant from the petition before the tribunal on the premise that they were not statutory parties to the petition. Their presence violates the express provision of the Electoral Act 2010 as amended. An open hearing of the third respondent motion during the pre-hearing session, the tribunal delivered its ruling together with the final judgment on the 29th day of March 2021, wherein the petition was dismissed and the application of the third respondent was granted. The names of the appellant and the sixth respondent were therefore struck out from the petition, including all the processes filed by or on their behalf. Now, the crux of this application is therefore centered on the tribunal decisions to strike out the name of the appellant from the petition. The appellant has approached this court via a notice of appeal dated 16th day of April 2021, challenging the decision of the tribunal striking out its names from the petition. It is imperative at this stage to state that the appellant and the fifth respondent in this appeal both filed an application which was taken on the 19th day of May 2021, the date the substantive appeal was heard by this court. On the aforementioned date, this court reserves the ruling in respect of both the application and the said ruling to be taken together with the decision of the court on the merit. I shall therefore at this stage proceed to deliver a ruling in respect of the application which has been reserved. Now, ruling on the motion. The appellant filed an application dated 30th day of April 2021 and filed on the 7th day of May 2021. The applicant is praying this court for the following reliefs. That is, an order of this court allows the appellant to rely on the supplementary record of appeal compiled and transmitted by the sixth respondent, Andrew Osagi Ezeamu, in his cross appeal in respect of this petition. Prayer 2 is an omnibus prayer. The ground upon which the application is made are contained on page 4 of this judgment, and attached to the said applications is an 8th paragraph of affidavit deposed to on behalf of the applicant at the registry of this court on the 7th day of May 2021 by one Okwesi Nkechi, a litigation secretary and a Nigerian citizen. In response to the said application, the civil respondent filed a 14 paragraphs of counter affidavit deposed to by one Odion Eric Namuna, counsel in the chambers of Ken Imozia SAN. By way of reply to the counter affidavit filed by the fifth respondent, the applicant on the 18th day of May in turn filed a 6th paragraph of further affidavit deposed to on behalf of the applicant by one Nelson Erabo, a male. The first, second, third, and sixth respondent did not file any process for or against the granting of the instant application. Now, before delving into the consideration of this instant application, it is important also to state that the fifth respondent filed a similar application to the applicant application under consideration. The application of the fifth respondent is dated 15th day of May 2021 and filed on the 17th May 2021. The fifth respondent application is brought pursuant to Order 4, Rule 10, Order 8, Rule 18, Sub 1, Order 19, Rule 3, Sub 1 of the Court of Appeal Rules and under the inherent jurisdiction of this court. The fifth respondent applicant application is praying this court for the following reliefs. They are all stated on page 6 of this judgment. The ground upon which the application is made also as stated on page 7 of this judgment. Attached to the fifth respondent applicant application is a 4-paragraph affidavit deposed to on behalf of the fifth respondent at the registry of this court on the 17th day of May 2021 by one Faith Okosodo, Mrs. In response to the fifth respondent applicant affidavit, the appellant in the instant appeal filed an 8 paragraphs of counter affidavit deposed to by one Nelson Erabo. Also in the application filed by the fifth respondent, the first, second, third, and sixth respondent did not file any process for or against the granting of this application. Now, after the perusal of both applications and relief sought therein, it is clear that while the appellant seemed to be a constructive application trying to save the appeal, the application of the fifth respondent, particularly the relief number 1 on the face of the motion paper, is destructive application, which seeks to put an end to the appellant's appeal. In practice and procedure is that where there is a constructive application to save an action and a destructive application to terminate the action, the former is taken and determined before the latter is considered, notwithstanding which one was earlier filed or was first in time in the sequence of filing them at the registry of the court. Cases were cited to support this position. It is on the premise of the above principle of law that I am fortified to consider the application filed by the appellant before that of the fifth respondent. Now, having carefully considered the reliefs sought by the appellant applicant on the face of its motion paper and also on the fact deposed in the entire gamut of the affidavit evidence, I am of the firm view that the crucial issue is whether in the circumstances of this case, this court ought to grant the appellant application. Now, the purpose of this application is grant leave to the appellant to rely on the supplementary record of the appeal compiled and transmitted by the sixth respondent, Andrew Osagi Izeamu, in his cross appeal. The fifth respondent, on the other hand, has vehemently opposed the granting of this application. A record of appeal is a reproduction of all that occurred in the court from which the appeal emanates. It consists of the proceedings and relevant processes used for the proceedings. Cases were cited to support this position. The record of appeal is an indispensable and integral part of the hearing of appeal. The applicant in the affidavit attached to the said application stated its reasons for not compiling the record of appeal in the instant appeal and why it is seeking an order of this court allowing it to rely on the supplementary record of appeal filed by the sixth respondent in his cross appeal. The reasons given can be gleaned from the fact deposed in paragraph 5 to 6 of the affidavit in support. They are all stated and captured on page 10, 11 to page 12 of this judgment. In opposition to the fact deposed in the appellant's affidavit in support of the application, the fifth respondent in its counter affidavit deposed to the following facts, particularly paragraph 5, which is stated on page 12, page 13 of this judgment. And in the appellant further affidavit, the appellant deposed to the following facts. They are also stated in page 14 of this judgment. Now, from the entire gamut of the affidavit evidence reproduced, about one fact that is not in dispute and which was admitted by the appellant is that it did not compile the record of appeal in the instant appeal. The reason for the non-compilation seems to be in dispute. While the appellant blamed the registry of the tribunal for compiling within time, the fifth respondent, on the other hand, defaults to the fact that the failure to compile was due to the refusal of the appellant to pay the filing cost requested by the registry. See paragraph 5 and 6 of the fifth respondent counter affidavit. Now, having carefully considered paragraph 5 of the fifth respondent counter affidavit, I am of the view that the third paragraph offends the provision of section 115 of the Evidence Act. For either of reference, permit me to reproduce the said section. Is stated on page 15 of this judgment. It is therefore evident that the fifth respondent failed to provide the name of his informant and his or her reasonable particulars, time, place, and circumstances of the information. The principle of law is that hearsay evidence, save for some exceptions, is generally inadmissible. The object of the evidence in paragraph 5 and 6 is to establish the truth that the appellant did not pay the cost of compiling and transmitting the record of appeal from the tribunal below to this court. It is on this note that I hereby proceed to expound paragraph 5 and 6 of the fifth respondent counter affidavit. As a matter of fact, Order 8, Rule 18 sub 2 of the Court of Appeal rules provide that where the appellant has not deposited the amount fixed by the registrar to cover the cost of compilation and transmission of the record of appeal as provided in Rule 2 sub B of this order, the registrar of the court below shall certify such the fact to the court which may suo motu order that the appeal be dismissed either with or without cause, and shall cause the parties to notify of the terms of the order, provided that the court shall only act on the certification by the registrar, the expiration of the 30 days allowed for the appellant to compile record by the appeal prescribed by Rule 4 of this order. There are no such certification by the registrar in the instant appeal in accordance with Order 8, Rule 18, sub 2 of the Court of Appeal Rules 2016. It is on the premise of this that I shall also not countenance the deposition of facts contained in paragraph 5 and 6 of the fifth respondent counter affidavit. However, the appellant on its own volition admitted to the fact that the record of appeal in the instant appeal was not compiled and transmitted. The appellant blamed the registrar of the tribunal for its failure to do what is required under Order 8 of the rules of this court. My gross with the reason furnished by the appellant is that assuming, but without agreeing, that the registrar failed to compile within time after the appellant had done everything incidental or consequential to the said compilations, to which payment of the necessary cost for compilation and transmission, what will a diligent party or counsel do in the circumstances? The rule of this court allows an appellant to compile the record of appeal in the event of failure of the registrar to do so. See Order 8, Rule 4 of the Court of Appeal Rules 2011. This the appellant failed to do. The prayer sought by the appellant is not a matter of course or right. Having gone through the affidavit evidence and the reason furnished by the appellant, I am of the considered view the appellant does not merit the granting of this application. The reason furnished for leave to rely on the supplementary record of the appeal transmitted by the fifth respondent are not justifiable, considering the nature of election petitions. I'm in total agreement with the deposition of the facts contained in paragraph 7 of the fifth respondent counter affidavit, that the appellants and its counsel excused for not compiling the record of appeal, that they did not know until it was too late, is admission of indolence and lack of diligence in prosecuting his appeal. The compilation and transmission of record of appeal in the process of appeal cannot be overemphasized. Where the records are not compiled and transmitted as prescribed by the rules, then an appeal will not be deemed to have been entered in the appellate court. All of the hue and cry of technicalities raised in the appellant further affidavit do not amount to bending the rules of court in favor of the other party, but more appropriately in applying the rules as they are. The parties will be gracious nonetheless to understand that in this case, we can only talk on meeting the end of justice only when the appeal is duly entered before the court. On the premise of the foregoing, I find no merit in the appellant's application, and same is hereby refused. The consequence of this is that there is no record of appeal upon which this appeal can be heard and determined. In an appeal of this nature, where only serious-minded parties and counsel are expected to be involved, it negates the dictate of common sense for a party or a counsel to give reasons such as the ones furnished by the appellant for failure to compile and to transmit record of appeal. Consequently, I hereby dismiss the appeal under Order 8, Rule 18 of 1 of the Rules of Court for failure of the appellant to compile and transmit the record of appeal to this court. Now, having refused the appellant application to rely on the supplementary record of appeal compiled and transmitted by the sixth respondent in the instant appeal, I find it unnecessary to consider the application of the fifth respondent on the merit. As such, same has become odious in the circumstances. On the other hand, courts are enjoined ex debito justitia to pronounce on every issue placed before it. It is the court's duty to pronounce on every issue properly placed before it for consideration and determination before arriving at a decision. It is no longer endowed that the Supreme Court demand of and admonish the lower courts to pronounce as a general rule on all issues properly placed before them for determination in order, apart from the issue of fair hearing, not to risk the possibility that the only issue or issue decided by them could be faulted on appeal. It is on this basis I shall proceed to consider the instant appeal on merit. Now, this is the appeal on merit. Now, in line with the rules of this court, parties file and exchange their respective brief of argument. Emmanuel I. Uso settled the appellant brief of argument, dated and filed on the 7th day of May 2021. For the determination of this appeal, the appellant formulated three issues for determination. They are all on page 20 of this judgment. The first, second, fourth, and sixth respondent did not file any brief of argument in respect of this appeal. The third respondent brief of argument is dated 14th day of May 2021, and the said brief was settled by Asuwaju Adeboyega Awomolo SAN, Chief Mrs. Victoria O. Awomolo SAN, Tunde Babalola SAN. The third respondent equally formulated two issues for determination. They are all contained and captured on page 21 of this judgment. The fifth respondent brief of argument is dated 14th day of May 2021. The said brief of argument was settled by Ken E. Mozia, SAN, BJ Owonikoko, SAN, Olusegun O. Jolao, SAN. And for the termination of the instant appeal, the fifth respondent merely adopted the issues formulated by the appellant. This appeal will therefore be heard on the appellant brief of argument, the third respondent brief of argument, and lastly, the fifth respondent of argument. Page 21 is argument and submissions of the counsel in respect of this issue. On issue 1 is the summary of the argument of the counsel, which is on page 22 down to 23, page up to 24, while issue on number 2, arguments of counsel was captured on page 24 down to page 25 to 26 of this judgment. Now, having carefully perused both the third, fifth respondents' brief of argument, it is obvious that their argument and submission are same in substance. They cruise in the same ships, and their common interest is to have this appeal dismissed. Therefore, it is on this premise that I find it unnecessary to reproduce the submission and argument of the fifth respondent in this appeal. It suffices to state that the fifth respondent counsel also urged this court to resolve issue 1 and 2 distilled by the appellant in favor of the fifth respondent and against the appellant. Now, this is the resolution of the said issue 1 and 2 distilled by the appellant counsel. Now, the Edo State election petition, the Edo State governorship election was conducted by the third respondent INEC on the 19th day of September 2020, wherein the fifth respondent hearing was declared the winner of the election. And is satisfied with the result of the election and declaration of the fifth respondent as the winner. The first and second respondent in this appeal approached the Edo State governorship election petition tribunal sitting in Benin City by a petition dated 5th day of October 2020 for the following declaratory reliefs. They are A and B. Now, the crucial issues in this appeal are whether the appellant hearing is a necessary party to the hearing of the petition, and whether the tribunal on the application of the first, second, and third respondent, now third and fourth, fifth respondent in this appeal, at the hearing of the petition, rightly struck out the name of the appellant from the petition, as rightly submitted by counsel for the fifth respondent at paragraph 4.1 of the fifth respondent of the brief. It is firmly established that election petition is a special procedure and therefore sui generis. One of the instances of this special nature of litigation is that rules and regulations guiding it enjoys strict adherence and are strictly interpreted. See the cases of Buhari against Yusuf, APC against PDP, PDP and others against Eze Onwuka, Abubakar and others versus Adua, Nelson versus Peter Side, all citation provided. In resolving the issues formulated by the appellant in the instant appeal, recourse must be made to the provision of Section 137 sub 1 and 2 of the Electoral Act 2010 as amended. The third section provides as follows. It is quoted extensively on page 28 of this judgment. So Section 3 of Section 137 of the Electoral Act supra goes further to provide that also is quoted on page 28 of this judgment. Now, from the above statutory provision of the Electoral Act, it is evident that there are two sets of parties statutorily provided for that may be joined as respondent to an election petition. These parties are one, an individual whose election is complained of, i.e. the winner of the election, and two, the other is INEC, i.e. the body statutorily empowered with the conduct of the election in Nigeria, and as rightly submitted by counsel for the third and fifth respondent, the provision of Section 137 of the Electoral Act supra exclude any other person from being joined as respondent to the election petition. And on who can be a respondent to election petition, the Supreme Court, Pagaladima JSC, in the case of APC versus PDP, citation provided, held as follows, and I quote, the law expressly specified and legislated on who can be a respondent in an election petition. Whosoever is contemplated to be a respondent to defend an election petition must fall into any of the two categories named in Section 137 sub 2 and 3 of the Electoral Act supra, unquote. The law having expressly specified on who can be a respondent in an electoral petition, it appears conclusive that whoever is contemplated to be a respondent to defend an election petition must fall in any of the two categories named in Section 137 sub 2 and 3 of the Electoral Act, and on whether a person who lost an election can be joined as a respondent in petition. My Lord Kalgo JSC, in the case of Buhari and others versus Obasanjo and others, citation provided held as those. I have captured the quotation on page 30 of this judgment. Now, the appellant in the instant appeal was a candidate who participated in Edo State governorship election, which was held on the 19th day of May 2020. The appellant undoubtedly lost the third election alongside its candidate, the sixth respondent herein in the instant appeal. I'm surprised that the appellant in its wisdom chose not to file a petition to challenge the declaration and return of the fourth and fifth respondent. The appellant was made a respondent in the election petition filed by the first and second respondent, who are petitioners at the tribunal, notwithstanding the clear and unambiguous provisions of Section 137 sub 1 and 2 of the Electoral Act supra. I'm of the firm view that the appellant cannot be said to be a necessary party to the hearing of the petition, because none of the relief sought in the petition is against it. It is on this premise that the tribunal rightly held at pages 3,270 to 3,271 of volume 5 of the record of appeal that, and I quote, we have looked at the petition itself and agree completely with the submission of the first, second, and third respondent that there are no claim or reliefs against the fourth and fifth respondent in this petition. We agree also that there is no ground of complaint against the fourth and fifth respondent in the petition, and also no facts have been alleged against them. Counsel to the third respondent in particular submitted that the fourth and fifth respondent have violated the provision of paragraph 12 sub 1 of the first schedule to the electoral act. We agree with the counsel on this, unquote. Now, having carefully perused the appellant reply on the petition filed by the first and second respondent, particularly at paragraph 36 of the appellant reply to the petition, I am of the firm view that there's a collusion between the petitioners and the appellant. For the avoidance of doubt, permit me to produce the averment contained in paragraph 36 of the appellant reply to the appellant petition, where the appellant stated that, and I quote, in specific response to paragraph 31 of the petition, the fourth respondent averred that the fifth respondent being a candidate sponsored by the fourth respondent at the election now subject of this petition of the petitioners conducted on September 19, 20, scored majority of the valid vote cast, satisfy the requirement of law thereof, and do hereby contend and pray that it is the fifth respondent sponsored by the fourth respondent who is entitled to be declared as winner of the election conducted by the fourth respondent on the 19th September 2020 and should be entitled to a certificate of return in the circumstances, unquote. While the first and second respondent as petitioners at the tribunal prayed for an order disqualifying the fifth respondent and nullifying the vote cast for him in the state governorship election held in Edo State on 19th day of September 2020, and ordering the third respondent to conduct a fresh election between all other qualified candidates, excluding the fourth and fifth respondent. The appellant herein pressed the tribunal to declare its candidate as winner of the election. This procedure employed by appellant who was supposed to file its election petition is rather confusing and appalling. The appellant had the right as to institute its own petition against the outcome of the election held on the 19th day of September 2020, but failed to do so. From the appellant prayer, it is clear as rightly submitted by Lanus Senior Counsel for third respondent that the appellant is camouflaging itself as a respondent when in actual fact it is a petitioner who is dissatisfied with the outcome of the election. My opinion in this regard is same as the position taken by the tribunal, 3,272 to 3,273 of volume 5 of the record of appeal, wherein the tribunal held that, I have quoted it extensively at page 34 of this judgment. I therefore agree with the counsel for the third respondent that the appellant pleading and seeking of such relief a respondent to the petition amount to complaining of an election in a manner other than filing an election petition, and such runs contrary to section 133, sub 1 of the Electoral Act, which I also quoted at page 34 of this judgment. Now, flowing from the heels of the above analysis, the respondent in an election must be those conceived statutorily by section 137 sub 2 and 3. Thus, there is no way the case of Ritraki Supra relied on heavily by the appellant will stand. This is simply because the principle of necessary parties, that is strongly hinged, bows interpretation before the unambiguous provision of section 137 of the Electoral Act Supra. As stated in the preceding part of this judgment, the presentation of election petition is very strict and technical, being sui generis. It does not admit for the kind of liberty available under the regular civil litigation. A petitioner is expected to adhere strictly to the rules guiding the presentation and prosecution of election petition. I have also carefully considered the case of Obasanjo and others versus Yusuf and the other Supra, relied on by the appellant in its brief and in course of adumbration. This case is inapplicable to the instant appeal in the light of section 137 of the Electoral Act. Obasanjo and others versus Yusuf and the other heavily relied on by the appellant was delivered on the 7th day of May 2004. In the third case, the Supreme Court held that, quoted on page 35 of this judgment. Now, the above decision seems to confer on the petitioner the sole discretion of deciding who to join with the statutory respondent in an election petition. Notwithstanding this court has considered and noted the decision of the Supreme Court in Obasanjo and others by Yusuf and the other Supra, as urged on it by the appellant counsel. However, in the light of the recent decision of the Supreme Court in APC versus PDP and the other Supra, delivered on the 14th day of April 2015, the unfettered discretion conferred on the first and second respondent as petitioners to decide who to join with the statutory respondent in an election petition has been eliminated. The case of APC versus PDP and other Supra is later in time, and this court is enjoined to follow the recent decision of the Supreme Court. The position of the state diocese is not for counsel to follow the decision he likes, but to follow the decision that is more recent. These are cases of Obiabu versus CBN, Obiako and others versus Okafo, CBN versus Zachary, Kanu versus Asuzu, all citation provided. The Supreme Court made it clear in the case of APC versus PDP, which I have quoted and cited in this judgment, Fagaladima JSC. Therefore, I am of the view that if the first and second respondent as petitioners at the tribunal run foul of the provision of section 137 of the Electoral Act, one cannot preclude the other statutory respondents from objecting to the first and second respondent non-compliance with the mandatory provision of the Act. On the premise of the above, therefore, the tribunal was therefore on the right footing when it did strike out the names of the appellant and sixth respondent hearing in the instant appeal from the petition. On this note, therefore, it is safe to conclude that this issue is resolved against the appellant and in favor of the third and fifth respondent. The appellant in its issue number 3 urged this court to evoke the provision of section 15 of the Court of Appeal Act to evaluate the arguments and the evidence adduced by the appellant, which was excluded when the tribunal reached its final decision. Having held that the tribunal was right to have struck out the appellant name from the petition, it will amount to a futile exercise of trying to get water from an empty well if the appellant's argument and submission under issue number 3 are considered. Since the tribunal correctly and rightly struck out the name of the appellant and the evidence adduced by the appellant from the petition, the argument therefore becomes odious with no meaningful judicial value to this appeal. This question as to whether this court can evoke section 15 of the Court of Appeal Act to evaluate the arguments and the evidence adduced by the appellant, which was excluded when the tribunal reached its final decision, cannot arise. On the whole, therefore, I find no iota of merit in this appeal. Same is hereby dismissed. The decision of the Governorship Election Petition Tribunal sitting at Benin, delivered on the 29th day of March 2021, quorum, Yunusa Musa J, Chairman, S.Y. Abubakar J, Member 1, O.O. Stanley J, Member 2, wherein the appellant name was struck out from the hearing of this petition, is hereby affirmed, and parties are to bear their respective costs. This is the judgment of this court.
Thank you. Thank you very much. Thank you. Thank you.
As the court pleases.
I was on this panel and I agree with the judgment just read. My learned brothers, Baba, JCA, Onyemenam, JCA, Wampai, JCA will in turn deliver their judgments. Justice Mbaba.
I too agree with the lead judgment.
Thank you. Justice Onyemenam.
I agree with the judgment just delivered.
Thank you. Justice Wambai.
Also agree with the judgment just delivered.
Thank you very much. That is the judgment of the Court of Appeal. Thank you. So, court.
Come on, close it.